ಕೊಡಿ ಸರ್, ನನ್ನ ಕಡೆ ಸಪ್ರೇಟ್ ಆಗಿ ಕೊಡ್ತೀವಿ. ಹಳೆ ಡೇಟ್
はい。
For page wise adjournment, list number 2, page number 1, serial number 1 to 3, page number 2, serial number 4 to 8, page number 3, serial number 9 to 13, page number 4, serial number 14 to 19, page number 5, serial number 20 to 23, page number 6, serial number 27 to 29, page number 7, serial number 30 to 33, page number 8, serial number 34 to 38, page number 9, serial number 39 to 46, page number 10, serial number 47 to 56.
The serial number 56, my lord. I am appearing for the respondent. Matter may be taken up next week, my lord.
Counsel for respondent number 256 next week.
Please, my lord. Please.
The request of counsel for appellant release this matter after 2 weeks.
Page number 11, serial number 57 to 64.
59. Yes. The request of counsel for the appellant release this matter after 2 weeks. You are appearing for appellant. Yes, let counsel for the respondent submits that this appeal may be called along with the claim.
Page number 12, serial number 65 to 70.
Serial number 70, my lord, after 10 days, my lord.
70. Yes, next week.
Yes, my lord.
Next week. The request of counsel for the appellant. 2 weeks. 66 after 2 weeks. The request of appellant.
Number 3, quota number 31 matter, page number 1, serial number 1 to 3, page number 2, serial number 4, number 1, for orders regarding non-compliance of office objection matters, serial number 9, serial number 1 to 10.
2 weeks time is granted to comply that office objection.
Hearing interrogatory application matter, serial number 11 to 14,
Notice.
15 and 16.
IA is dismissed, not pressed, issue notice.
Admission matter 17 to 30.
Notice.
Number 3, quota number 31 matter, hearing interrogatory application, serial number 1, Ramesh for appellant, CH Janmati.
Yes. There is a delay of 125 days in filing an appeal. IA 1 of 2017 is filed for condonation of delay for the reason stated in that accompanying affidavit. Delay of 125 days in filing an appeal is controlled. IA 1 of 2017 is allowed.
Serial number 2, there is Shyam Prasad for appellant, connected matter, B. Ravi.
Yes, Shyam Prasad. Ready? Ready? What ground you are challenging me?
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಲಕ್ಷ್ಮೀ ನರಸಪ್ಪ ಸರ್.
Serial number 5 only. P. Pradeep is directed to take notice for respondent number 1. What about respondent number 2, Mr. Shyam Prasad? Dispensation. Learned counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. Delay of 136 days in filing an appeal. IA 1 of 2017 is filed for condonation of delay. For the reasons stated in the accompanying affidavit, delay of 136 days in filing an appeal is condoned. IA 1 of 2017 is allowed.
Confusion matter, serial number 3, A. Venkatesh for appellant, connected matter, Alesha Archi.
My lord, ಇದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಕ್ವಾಂಟಮ್ ಕ್ವಶನ್ ಮಾಡಿದ್ದೀವಿ, including liability. Matter may be taken up next week, my lord. We will assist the court, my lord.
Serious this matter at the request of counsel for the appellant next week.
Please, my lord, oblige.
Final hearing.
Next Thursday.
Sorry, soon.
Final hearing matter, serial number 4, Alesha Archi for appellant, connected matter, B.C. Sitaram Rao.
Yes, Mr. Ramesh.
I am seeking enhancement for affidavit.
Thursday.
Delay is 4 days delay in filing an appeal or appeal. And the explanation is given in appellant itself.
The other side is Thursday. Yes, release this matter on Thursday.
Number 2, for order, serial number 1, B. Pradeep for appellant, CH-16.
Yes. 2 weeks time is granted to do the needful.
Serial number 2, Kamala D.K. for appellant, B. Pradeep.
For the appellant.
Yes.
It's already plus allowance 84 of 2028. First,
Now,
individual considers the appellant allowance.
now what you say about that process in respect of respondent number 1 to yes. Where is that R1 is refused? R1 party refused. Yes. Notice issued to that respondent number 1 by this court is written with posted shara. That respondent number 1 is refused. Hence, service of notice to R1 is held sufficient. 2 weeks time is granted to pay the process to issue notice to respondent number 3. Call this matter along with that. Yes.
Serial number 3, Shivakumar C. for appellant, Keshava Prasad.
Yes. 3 weeks time is granted to do the needful.
Serial number 4, Gopal Krishna N. for appellant, Ravish Sankar.
Ready? Learned counsel for the appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed at the risk of the appellant. There is a delay of 292 days in filing an appeal. IA 1 of 2020 is filed for condonation of delay. For the reasons stated in the accompanying affidavit, delay of 292 days in filing an appeal is condoned. IA 1 of 2019 is allowed subject to condition. Appellant is not entitled for the interest for a period of 292 days. Yes, Mr. Gopal Krishna. 2017. 9,000. What is your claim? 11,000 is that. Sorry. What about that future prospects? Madidara? Madila. What is his age? 10%. 1/4 has correctly rejected. Who are the claimants? Interest 6%. Right. Shri Gopal Krishna N. Learned counsel appearing for claimant has contended that At the time of the accident, deceased was earning 25,000 per month. Tribunal has assessed notional income of the claimant as deceased as 9,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Pranay Sethi, 10% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Per contra, Shri V. Pradeep, Ravi Samprati, learned counsel appearing for insurance company has contended that even though the claimant has claimed that deceased was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 9,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Tells what is the name of deceased? Muni Venkappa died in road traffic accident occurred on 13/11/2017 due to rash and negligent driving of rider of two-wheeler bearing registration number KA 07 S1384. Even though claimant has claimed that deceased was earning 25,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2017, the notional income has to be considered as 11,000. At the time of the accident, deceased was aged about 52 years. In view of judgment of apex court in case of Pranay Sethi, 10% of the income of the deceased has to be added for future prospects. Since there are 4 dependents, 1/4 of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to that is, what is that multiplier? 11. Accordingly, the loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. Claimant number 2 and 3 are entitled 40,000 each for parental consortium. The claimant number 4 is entitled 40,000 for filial consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal. In view of that order dated so and so, the claimant is not entitled for the interest for a period of 292 days. Each time is granted to do the needful. Yes. Each time is granted to do the needful. Yes. Yes. Lakshmi Narsimha is a insurance company now. Yes. Who is that? Issue memo filed for dispensation of notice to R2 is dispensed. Who is that? Lakshmi Narsimha? Lakshmi Narsappa. ಲಕ್ಷ್ಮೀ ನರಸಪ್ಪ ಎಂ ವೆಂಕಟೇಶ್ ಅವ್ರ ಕಲಿಗಲ್ಲ ವಕಾಲತ್ ಯಾರು ಹಾಕಿದಾರೆ ನೋಡಿ. ಲಕ್ಷ್ಮೀ ನರಸಪ್ಪ ಅವರು ವೆಂಕಟೇಶ್ ಅವ್ರ ಕಲಿಗಲ್ಲ. ಎಸ್. ವಾಟ್ ಈಸ್ ದಟ್? Yes. What is that income assessed by the tribunal? New Year 2018. 12,500. New Year claim ಮಾಡಿದ್ರಾ? That is the only issue. Other you will not press for. Then what about that future prospects they added? Only the yes. Shri K.T. Gurudev Prasad, Learned Counsel appearing for claimant has contended that at the time of the accident, deceased was earning 20,000 per month. Tribunal has assessed notional income of the deceased as 9,000 is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri K.S. Lakshmi Narsappa, A.M. Venkatesh, Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. Under that circumstances, the tribunal has rightly assessed the notional income of the deceased as 9,000 per month. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. Sundar died in road traffic accident occurred on 15/10/2018 due to rash and negligent driving of driver of lorry bearing registration number AP04 TX2786. Even though the claimant has claimed that deceased was earning 20,000 per month, they have not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income has to be considered as 12,500. The tribunal has rightly added 25% of the income of the deceased for future prospects and rightly deducted 1/3 of the income of the deceased for personal expenses. The multiplier applicable at the time of the accident, deceased was aged about 45 years. The multiplier applicable to that age group is 14. Accordingly, loss of dependency has been reassessed as follows. The enhanced compensation amount carries 6% interest. The compensation awarded by the tribunal in the other hand are just and reasonable. The insurance company is directed to deposit 90% of the award amount with interest within 6 weeks from date of the discovery. And 90% directed to deposit 90% interest. Yes. IA 1 of 2021 is allowed. Delay of 20 days is controlled.
This is Shivane Gowda for appellant.
2 weeks time is granted to do the need. Yes. Yes. Office note shows that The connected appeal filed by insurance company in MFA 4136 of 2018 is pending before division bench. Hence, post this matter along with that MFA 4136 of 2018 before the division bench having a roster after obtaining necessary order from Honorable Chief Justice. I'll connect myself. Nagaraj Reddy Renuka. Week's time is granted to do the needful. Yes, Manjunath. Ready. Notice to R1 is dispensed. Yes. Yes, Mr. 2012. Berlin the Yanagita, Wapas answer is remand agit. Why it has been disposed in 20? What is that income he was earning 15,000? Tribunal estandiದ್ದಾರೆ. Tribunal estandiದ್ದಾರೆ. Tribunal estandiದ್ದಾರೆ ಅಂತ 9,000 ತಾಂಡಿದ್ದಾರೆ. ಹಾಗಾದ್ರೆ ಅದರಲ್ಲಿ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. There is no dispute regarding that income. Then 16 days. What is that disability, Mr. Tribunal ಎಷ್ಟಾಡಿದ್ದಾರೆ? ಡಾಕ್ಟರ್ ಏನು ಹೇಳಿದಾರಪ್ಪ? Petitioner has sustained 20% disability of this so and so 40% permanent disability due to that injury sustained by him. Some disability, the actual disability petitioner sustained, but the said sustained clearly indicated doctors also. Out of 45%, defined by the doctor, 1/3, 45% ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ ಲಿಂಬಿಗೆ, 15% ತಾಂಡಿದ್ದಾರೆ. ಸರಿ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ. Income has taken 9,000. In respect of that loss of future earning has been rightly assessed by the tribunal. 16 days loss of earning during the treatment period 1 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೊಂದು 2 ತಿಂಗಳು ಮಾಡಬಹುದು. Attendance charges, food and nourishment 20, 40. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಯಾಕೆ? Why the tribunal has granted only 7? Where is that discussion, Mr.? Where is that discussion regarding the medical expenses? All right. Where is that, Mr.? Petitioner said accepting that medical bill produced so and so the medical bills are revolves that 7,399 only medical bills. 1 lakh ರೂಪಾಯಿ ಇಲ್ರಿ. Where is that 1 lakh, Mr.? Yes, Mr. In addition, Tara? That is your claim petition, your contention. But you have produced that medical bill only that, Mr. Yes, in addition, 60,000 rupees, Mr. Yes, in addition, 60. Tally. So and so, learned counsel appearing for the claimant has contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 16 days. He has suffered a lot of pain during the treatment. Doctor has assessed the disability 45% to particular limb. He has to suffer this disability and unhappiness throughout his life. The compensation, the overall compensation awarded by the tribunal is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri V. Pradeep, learned counsel appearing for insurance company has contended that considering that injury suffered by the claimant, considering that evidence of the doctor, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 19/1/2012 due to rash and negligent driving of driver of auto bearing registration number KA09 TR 6905/2011 and 12 in temporary registration. Yes. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 16 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am of the opinion, in addition to that award, in addition to that compensation awarded by the tribunal, 60,000 has been awarded with interest. Accordingly, the appeal is disposed of. Yes.
The opinion in this case,
Hmm.
it's a bachelor's test.
Yes.
There are three opinions. Reports are required.
Yes. Notice to R1 is dispensed at the risk of the appellant. What about that R3? Week's time is granted to pay the process to issue notice to respondent number 3. Yes.
Liabilities on our
R3. What you want now for R3? Given a memo, then you have filed a memo only for R1. Give that memo. Learned counsel for the appellant has filed a memo seeking dispensation of notice to R1 and R3. Memo is taken on record. Service of notice to 1 and 3 is dispensed at the risk of the appellant. Yes. Memo 31. No. Now you have to take a notice for who is that respondent. Then you have to take notice. Yes, week's time is granted to furnish correct address, pay process fee, issue notice to respondent number 1. Yes. Yes, emergent notice. B. Pradeep, respondent number filed in a memo for dispensation of notice to R1 is dispensed. Delay of 112 days in filing an appeal is condoned. Respondent number 2 served unrepresented. B. Pradeep is directed to take notice. Yes. Memo for dispensation of notice to R1 is dispensed. Ready? Yardo is in climates appeal. Where is Surya Narayan drop? Yes, delay of 281 days in filing an appeal is condoned. IA 2 of 2019 is allowed subject to condition not entitled for the interest. Is this matter along with that? Yes. Insufficient address. You have to furnish correct address list. Yes. Week's time is granted to furnish correct address, pay process fee to issue notice to R1. Notice to R1 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತೋರಿಸ್ತದಾರೆ ಇದ್ರಲ್ಲಿ. R2. Yes.
A paper appellant, my lord. There is a delay of 20 days in filing appeal, my lord.
Yes. IA 1 of 2020 is allowed. Delay of 20 days in filing an appeal is condoned.
Notice to both.
Take notice for R2, my lord. I'll take notice for R2.
Yes.
Sir.
A. Kumar is directed to take notice for respondent number 1. Yes. Office is directed to show his name.
I appear for appellant, my lord.
Yes. IA 1 memo filed for dispensation of notice dispensed. IA 1 of 2019 is filed for condonation of delay. Delay of 8 days is condoned. IA 1 of 2019 is allowed. Heard admit.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಅವರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ. ಜನಾರ್ದನ್ ರೆಡ್ಡಿ ಡೈರೆಕ್ಟ್ ಟೇಕ್ ನೋಟಿಸ್.
Yes. India Insurance Company. Respondent number 2 third. Janardhan Reddy is directed to take notice. Admit. Numbering.
ದಿಸ್ ಕೇಸ್
ಇದರಲ್ಲೂ ಅದೇ ಸೇಮ್
ಹೌದು. ಇದು ಯುನೈಟೆಡ್ ಇದು ಅದೇ ಜನ ಇವ್ರಿಗೆ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಮತ್ತೆ ಇನ್ನೊಂದು 4096 of 19.
Memo filed for dispensation of notice to R1 is dispensed. Delay of 185 days in filing an appeal is condoned subject to not entitled for the interest. United India Insurance ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ಅದು ಇವರು ಶಂಕರ್ ರೆಡ್ಡಿ.
Shankar Reddy is directed to take notice for respondent number 2. Yes.
20 is connected with 19. Another matter 4096 of 19 is also connected.
Serial number 20 dispensation notice to R1 185 days condoned denied interest. Shankar Reddy is directed to take notice for respondent number 2. Learned counsel for the appellant submits that this appeal may be called along with the sold.
4096 of 19 ಇವು ಎರಡು ಜೊತೆಗೆ ಅದೊಂದು.
Yes. 21
ಇದರಲ್ಲೂ ಅಷ್ಟೇ ಜನಾರ್ದನ್ ರೆಡ್ಡಿ.
memo for dispensation of notice to R1 is dispensed. IA 1 of 2019 is filed for condonation of delay. Delay of 275 days in filing an appeal is condoned. Janardhan Reddy is directed to take notice for respondent number 2. Yes. Yes. Furnishing of fee of issue notice. Week's time is granted to do the needful. Yes. Notice to respondent number 1 is dispensed at the risk of the appellant. Delay of 16 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Yes, ready? Yes. Forty-five years agriculture. Forty-eight years. Yes. What is that income? is 9,500. What is the disability, Mr.?
10%.
Correct is that.
9%.
How many days you were in hospital?
66.
9 days or 6 days? 9 days. Pain and agony 20. Loss of income during the treatment period. One thing ಕೊಟ್ಟಿದ್ದಾರಾ? Discomfort. Yes, that's all, Mr. Thank you. Yes. Yes. Learned Council for appellant contended that at the time of the accident, claimant was earning 20,000 per month. The tribunal has considered notional income of the claimant as 6,500 is on lower side. He further contended that due to the accident, the claimant has suffered grievous injury, was inpatient for a period of 9 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Shankar Reddy Learned Council appearing for insurance company has contended that even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income of the claimant as 6,500. He further contended that considering that evidence of doctor, considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, Perose, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 29/12/2016 due to rash and negligent driving of rider of motorcycle bearing registration number KA11 EA 2418. Even though the claimant has claimed that 20,000 per month, he has not produced any document to establish the same. Therefore, the notional income has to be considered as per guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2016, the notional income has to be considered as 9,500. The tribunal has rightly assessed whole body disabilities 10%. The multiplier at the time of the accident, he was aged about 40 years, the 48 years. The multiplier applicable to that age group is 13. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 9 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 20,000 to 40,000. Food and nourishment conveyance charges has to be enhanced from 8,000 to 15,000. Loss of amenities has to be awarded from 10,000 to 35,000. Loss of income during the later period for 2 months. The enhanced compensation amount carries 6% interest. Accordingly, disposed of. Yes.
CS Krishna. Serial number 24.
Yes, one ready. Who is PS Krishna? Yaro PS Krishna.
ಅವ್ರು ಯುನೈಟೆಡ್ ಗೆ ಅಪೇರ್ ಆಯ್ತಾರೆ, ಯುನೈಟೆಡ್ ಗೆ.
He is not regularly ಬರ್ತಾರಾ? PS Krishna, I have not. Furnishing a fee of what you say about that respondent number 2, Mr. Dispensation. Internet Council for the appellant has filed in a memo. Dispensation of notice to R2. Notice to R2 is dispensed. Delay of 17 days in filing an appeal is controlled. IA 1 of 2019 is allowed. None appear for respondent number 1. As a last chance, please this matter next week. Notice to R1 is dispensed. Delay of 6 days in filing an appeal is controlled. United India. You are there, Mr. Nagaya. Nagarajaya. Respondent number 2 is served unrepresented. K. Nagarajaya is directed to take notice for respondent number 2. Internet Council for the appellant is served. Copy code.
This case also National Insurance served. Janardhan Reddy, I served copy and Janardhan Reddy.
Memo filed to R1 is dispensed. IA 1 of 2019 is filed for condonation of delay. 69 days delay in filing is controlled. National Insurance Company, you are there. Yes. So and so is directed to take notice for respondent number 2. The net counsel for the appellant is directed to serve. Next
It may
week.
Next week it may be death case. It may be.
Yes, next week. Yes. He will serve the copy. Yes. Directed to serve one set of copies.
ಯಾರಿಗೆ ಹೇಳಿದ್ದೀರಿ ಇದು?
Tejaswini.
ಮಂಜುಳಾ ತೇಜಸ್ವಿ.
Yes, yes. Yes. Notice to R1 is dispensed. Delay of 122 days is condoned. Yaro Patila. Ashok and Patil is directed to take notice. At the request, refer the matters to Lok Adalat. Notice to R1 days is condoned. United India, ready over there.
Janardhan.
Shankar Reddy, you served the copy to Shankar Reddy.
Yes, I'll serve Shankar Reddy. Yes.
R2 is served unrepresented. Shankar Reddy is now, why no insurance company is ready to file an wakalat nowadays? Why? They have decided. Alla yaudilla, national illa, United illa, Div India illa. Yes, any of that you take notes. Yes.
It may be called next week. My death case, it could be disposed
Yes,
of.
next week you get in.
I appear for appellant, my lord.
Yes, memo for
R2 is the owner of the vehicle.
dispensed.
There is a delay 51 days, my lord.
Condoned. Ready?
Yes, my lord.
Ready, Mister? Yes.
The case of injury, my lord. The accident happened on 26/6/2013, my lord.
Yes.
The appellant has sustained the fracture of right fibula.
Yes.
He was treated as inpatient for 3 days.
3 days.
3 days.
Yes.
After complete treatment, there is a permanent disability to the extent of 10% to the whole body.
Yes.
The tribunal has taken only 4% to assess the loss of future earning.
Where is that discussion, Mister?
Disability at para 19 of judgment, my lord.
Not a treated doctor, but he has assessed the disability only to 5 years after the accident. Admittedly, fracture is initiated without so and so. It appears that stage of the whole body disability is assessed 10% for the said fracture. 5 years to the accident appears to be exorbitant, taking into the consideration of the evidence. What is that limb disability, Mister?
In this case, my lord, limb disability is not considered, my lord. Only whole body disability is considered, my lord.
Yes. Tribunal, how much is assessed?
4%, my lord.
Yes.
Regarding loss of earning is concerned, my lord.
Yes.
The tribunal has awarded 2 months at the rate of 6,000 per month.
What is that income, Mr. Girimala?
12%, 12,000 per month, my lord. Claimed income is
What is that consideration of the tribunal?
6,000 per month, my lord.
2013.
13, 8,000 is. Regarding loss of amenities, conveyance, food and nourishment and attendance charges, overall 20,000 is awarded.
Income during the treatment period,
12,000 is awarded.
2 months ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, man, at the rate of 6,000.
Loss of amenities, conveniences, food and nourishment to 20,000.
That is on the lower side, man.
Yes.
These three heads is
But interest.
interest is 8%.
Yes, Mr.
Doctor, not a teacher doctor.
Yes.
People take it is only 4% doctor.
Yes.
Is a year 57 years.
Yes.
Resulting outcome is only income, bottom income.
Yes.
According to guidance, 98,000.
Shri.
Regarding age is concerned, my lord, at the time of the accident, 55 years. At the time of filing the appeal, he was 57 years.
No, that 55.
55, my lord.
Where is the consideration of the tribunal?
55, 11 is considered, man. Multiplier 11 is considered.
11 consider ಮಾಡಿದ್ದಾನೆ. Then you said 55.
In appeal, there is a 57 years.
Yes. 55, 11 correct ಇದೆ. Yes. Shri Kirimalaya, Learned Counsel appearing for claimant has contended that at the time of the accident, he was earning 12,000 per month. Tribunal has considered the notional income of the claimant as 6,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered previous injury. He was inpatient for a period of 3 days. He has suffered a lot of pain during the treatment. He has examined the doctor. Doctor has assessed whole body disabilities is 10%. The tribunal has assessed whole body disabilities 4% is on lower side. Lastly, he has contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 3 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and agony, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Sri Nagarajaya K, Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 12,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 6,000 per month. He further contended that the claimant has examined the doctor as PW2. He is not a treated doctor. He has examined the claimant after 5 years of the accident. Therefore, tribunal has rightly assessed the whole body disabilities as 4%. Lastly, he has contended that considering that the evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident Takada 26/6/2013 due to rash and negligent driving of driver of right which vehicle motorcycle
Yes.
bearing registration number. What is that registration number, Mr.?
KA42H2747, man. KA42H2747.
Rider of the motorcycle bearing engine. But engine number ಕೊಟ್ಟಿದ್ದಾರಲ್ರಿ.
Earlier, vehicle was not numbered. Subsequently, it was numbered. It has come in the judgment also. KA 42H 27.
A 42 H
2742 47.
27. Yes. Due to that extent, the claimant has suffered the following injury. He has examined the doctor Prakashappa as PW3. He is not a treated doctor. He has examined the claimant up to 5 years of the accident. Even though he has assessed 10% disability to whole body, he has not assessed limb disability. Since fractures are united, the tribunal has rightly assessed whole body disabilities is 4%. Even though the claimant has claimed that he was earning 12,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has, therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2013, the notional income has to be considered as 8,000. Accordingly, loss of future earning has been reassessed as follows. At the time of the accident, he was aged about 55 years. The multiplier applicable to the age group is 11. Accordingly, loss of future earning has been reassessed as follows. $42,240. Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 3 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for loss of amenities, conveniences, food and nourishment attendance charges from 20,000 to 50,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. For pain and suffering from 40 to 50,000. Other hand, just and reasonable. Accordingly, the enhanced compensation amount carries 6% interest. Accordingly, the appeal is disposed of.
Much obliged.
Yes. You will refer. Yes, dispensation of notice to R1 is dispensed. Allowance of 178 days delay in condone, not entitled for the interest. At the request, refer this matter to Lok Adalat. No, this council, in all matters, he is to get it referred. That's also one rank which is correct. Yes. Yes. Delay of service ಎಲ್ಲರಿಗೂ ಆಗಿದೆಯಾ ಮತ್ತೆ ಫೈಲಿಂಗ್ ಆಫ್ ಅನಿಲ್ ರೆಡ್ಡಿ ಸಿನ್ಸ್ ಯಾರು ಅನಿಲ್ ರೆಡ್ಡಿ ಕೊಡಿ issue notice Shri Anil Reddy Karnataka Council has filed an wakalat for respondent number 1. The same is accepted. Issue emergent notice to respondent number 2 to 5. Yes. Stay you want deposit entire amount. Purti katti. Delay idiyala. Yes. Heard. Admit the issue notice. Stay of judgment and award dated 1st October 2019 passed by MACT Bhadravati in MEC 623 of ಎರಡು ಕೇಸ ಯಾವ್ದ್ರ ಇದು which is that MEC Mr. 624 of 2016 subject to deposit the entire compensation amount with interest before the tribunal within 4 weeks from today. Yes, Mr. Ramesh. Memo filed for dispensation of notice to R1 and R2. Yes, dispensed. Delay of 215 days in filing an appeal is condoned. IA1 of 2020 is allowed subject to condition not entitled for the interest. Yes, ready? Pass out. Yes. Memo for dispensation of notice to R1 is dispensed. Yes, madam, delay we can condone. 304 days. Yes, delay of 304 days is condoned, interest denied. Yes, what is this matter, madam?
False computation.
On what ground?
Enhancement.
What is the substantial question of law, madam? Yes. Secure records. Office is directed to secure original records from the tribunal. What is to respondent number 1 na memo kodi. Filed in a memo dispensed. IA1 of 20 is dismissed as not trust. Divisional manager, United India Insurance Company. Were they ready? Yes, ready is directed to take notice. Respondent number 3 is served unrepresented. Ready is directed to take notice for respondent number 3. Bernard counsel for the appellant is directed to serve one set of copies. IA1 of 20 is dismissed as not trust. Ready? How much? Huh? What is his age, Mr.? 22 years. No.
₹8,721 has been awarded.
Doctor has to disability.
Doctor has given 20.6% to disability. Because he was working in doctor has given 20.6%. They not taken the task. Number 17, para number 12 of the trial court judgment.
Yes, any judgment you have?
The ITC was made by ITC and I think 19,000.
You are
That's why the tribunal did not grant any.
Where is that discussion? Mr.?
Page 9 of the judgment.
Yes. Tara?
Kindly see the page number 11. Prior to that, kindly see the page number 11.
So where is para 11 discussion? Which para, Mr. Reddy?
11 roll number 11. Para number 12. ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅರ್ಜಿಯನ್ನು ದಿನಾಂಕ 3/3/2017 ಮಧ್ಯಾಹ್ನ 2:50 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕಾಲೇಜಿನಿಂದ ತನ್ನ ಮನೆಗೆ ಕೆಡಿಸಿ ನಗರದ ಗಾಂಗೆ ಪಾರ್ಕ್ ನಲ್ಲಿ ಬರುತ್ತಿದ್ದಾಗ ಕಾಲೇಜ್ ವಾಸ್ ಸ್ಟೂಡೆಂಟ್ ಮೇಡಮ್. Consequently, he was appointed and in the ITC form and getting the salary money. But at the time of the accident, he was a student.
ಆಯ್ತ್ರಿ ಆಮೇಲೆ ವೆದರ್ he has continued in this work.
He is in work.
ಮತ್ತೆ what is the loss?
Software engineer. For that reason, but my lord, he was the student and he expected.
ಆಯ್ತ್ರಿ.
All legal, my lord, but he expected the. But due to that impact, my lord, he didn't get the. Moreover, my lord, even till the date, he is unable to work properly.
Where is that record? Record is in. We'll secure the records. Yes. Out admit. Full 82 days delay. Third, issue notice. Stay of judgment and award dated 3rd September 2019 passed by MECT Arsikare in MEC 1772 of 2015. Subject to deposit entire compensation amount with interest before this court within 4 weeks from today.
Before MAC. Is the same, huh? Enter. Third issue notice stay of order dated 17th December 2019 passed by Bangalore, MACT Bangalore in MEC 5153 of 2018 subject to deposit entire compensation amount with interest before the tribunal within 4 weeks.
38.
Yes, on what ground you are challenged, Mr. No permit. Pay and recovery madilva. What is the finding of the tribunal? Yes. Third issue notice stay of judgment and award dated 22nd March 2020-22 passed by MACT Udupi in MEC, which is that MEC 584 of 2018, subject to deposit 50% of the award amount with interest before the tribunal within 4 weeks. from today. IA 1 of 22 is dismissed as not trust. Yen challenge madidra? Why? Issue notice stay of judgment and award dated 14th January 2022 passed by MACT Bangalore in MEC 1371 of 2019, subject to deposit 50% of the award amount with interest before the tribunal within 4 weeks from today.
What is this credit for appellant?
Negligence. Why? 25% negligence against the driver of the goods vehicle. In fact, the police officer, out by 25%, he made 75%. Yes. Third issue notice stay of judgment and award dated 31st December 2021 passed by MACT Bangalore in MEC 66P2 of 2018, subject to deposit 50% of the award amount with interest within 4 weeks from today. IA dismissed as not trust. Yes, usually MEC number matra there. Yes. Yes. Yes, Mr. Mahesh. But you are pleading inconsistent pleading. No, which is that village actually? In the order, it is mentioned in only one place, Allah. There are three LL there.
Bogadi, situated at Bogadi. Para 2 ಮತ್ತೆ 3 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? Land petitioner Guntas petitioner measuring so and so situated in Bogadi. 3, 2, 3 and
page number 6 ಅಲ್ಲಿ ಇರುತ್ತೆ ಲಾಸ್ಟ್ ಕೆಳಗಡೆ
page number 6. Bogadi. Where is that notification? Is it Bogadi village or this thing? Lalitadripura village. Bernard Council for the petitioner has filed an IA for correction of order dated 17/2/2022. The ground that instead of Lalitadri village, it has been typed as Bogadi village in para 2, 3 and 6 of the judgment. This has not been disputed by other side. Accordingly, IA 2 of 2022 is allowed in order dated 17 February 2022 in para 2 and para 3 and 6 in place of Bogadi, Lalitadri has to be Lalitadri Pura has to be added, has to be replaced. Office is directed to as replaced. Office is directed to issue corrected copy to the parties. That's accordingly here disposed of. ಅದು 3 ಕಡೆ ಇದೆ ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು ಪಾಸ್ವರ್ಡ್ 230 ಶಾರದಾಂಬಾ here Pradeep ಪಾಸ್ವರ್ಡ್ yes ready. Yes, then records idea. Yes.
Going in auto, we pay FSRC buses. So at the time of accident, he was traveling in auto. So the FSRC bus coming in opposite side. So
ಆಟೋಕ್ಕೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಹಾಕಿದ್ದಾರೆ? ಆಯ್ತು. ಮತ್ತೆ
ಆಟೋ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. So that the auto driver also died at the same accident. So APSRC bus
ಯಾಕೆ ಅವ್ರ ಆಟೋದಾರ he is not disputing what is your grant? He was no more ಅಲ್ಲ ಆಯ್ತ್ರಿ ಅವ್ನ್ ಸತ್ರ ಏನಂತ್ರಿ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಇಲ್ವಾ? You recover from his legal representative. ಗೊತ್ತಾಯ್ತು ಜಾಯಿಂಟ್ ಆಫೀಸರ್ ಅಲ್ಲೋಗಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ
ನಾವಲ್ಲ ಸರ್ ಇದರಲ್ಲಿ ಇದೇನು ಹೇಳ್ತಾರೆ ಸರ್ ಜಾಯಿಂಟ್ ಆಫೀಸರ್ several nature apportionment or determination are implemented killed required in case of joint and several liability entire compensation shall be awarded as its sole immediate officer. The interest liability of joint will be worked out independently. And the victims what which is the record in the
now in view of that you can get a compensation from any one of them. Go and execute against that APMC entire compensation. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಇಟ್ಕೊಂಡು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಕೇಳಿ ಕೊಡ್ತಾರೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ. ಆಟೋದ ಮೇಲೆ 50 ಬಸ್ ಮೇಲೆ 50 ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಿಮಗೆ ನೀವು ಯಾರ ಮೇಲೆ ಬೇಕಾದ್ರೆ ರಿಕವರಿ ಮಾಡ್ಕೋಬಹುದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದಾರೆ.
You go and recover against that APFs.
ನಮ್ ಕೇಸಲ್ಲಿ
ಇದ್ರಲ್ಲೇ see ಈ Supreme Court judgment ಇಟ್ಕೊಂಡು you go and claim in the execution itself we can claim it.
our case, honorable court is.
Yes, third admit. In your case, the auto driver has not challenged that, mister. He has not challenged. How you can say that?
You have no moral. So ಹಂಗಾಗಿ ಯಾರು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದಾರ they can
That you can work on. You file an execution. Sought for that. If they reject, then you can move this matter. Yes, third admit. Execution ಅಲ್ಲಿ claim ಮಾಡಬಹುದು.
ನಾವು ಮಾಡೋದು honorable court ಮಾಡಿದ್ರೆ
You go and see that CPC. What is the power of the execution court ಅಂತ?
particular case ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
Yes, then you will see. Yes. Yes, what is this, Mr. Raj? Alla, ಏನು why is that? 25 years. What is the document she has produced? ಮತ್ತೆ 12 ಅಂತಂದ್ರೆ 7,000. ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಮತ್ತೆ but that is right. 13% ಕೊಟ್ಟಿದೆ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? ಆಯ್ತು, only income you will reduce and dispose of. That even after 2 years also same thing, 7,000. That's all. Right. Shri Rajshekar S, Learned Counsel appearing for corporation has contended that even though claimant has claimed that he was earning, just claim ಮಾಡಿದ್ರು 25,000 per month. He has not produced any document to establish the same. The tribunal, while assessing notional income, 35,000. Yes, he has claimed 35,000 per month, but he has not produced any document to establish the same. The tribunal, while assessing the notional income, has considered 9,000 per month is on higher side, even as per the chart prepared by Karnataka Legal Service Authority. For the accident occurred in 2012, the notional income is fixed as 7,000. Secondly, he has contended that the injuries suffered by the claimant are minor in nature. He was inpatient. How many days?
15 days, sir. 15 days.
He was inpatient for a period of 11 days, hospitalized antara. Yes, 15 days inpatient. The whole body disability is assessed by the tribunal. 13% is on higher side. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is also on higher side. Hence, he sought for reduction of compensation. Lastly, he has contended interest. Lastly, he has contended that in view of judgment of this court, the interest awarded by the tribunal is 9% is on higher side. Per contra, Shri Rajanna, Learned Counsel appearing for claimant has contended that at the time of the accident, the claimant was earning 35,000 per month by doing a timber work and also from agriculture property. He was earning 25,000 from timber work, 8,000 per month from timber work, 25,000 from agriculture work, and 2,000 from dairy, 2,000 from milk vending. Considering the same, the tribunal has rightly assessed
the notional income as 9,000 per month. He further contended that due to the accident, the claimant has suffered previous injury. He has examined the doctor. Doctor has assessed that whole body disabilities is 13%. Considering that evidence of doctor, the tribunal has rightly assessed the whole body disabilities. Lastly, he has contended that considering that evidence of doctor injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 20th/11/2012 due to rash and negligent driving of driver of bus bearing registration number KA ಯಾವುದು ನಿನ್ bus KA 06F493. Due to that accident, the claimant has suffered the following injury. He has examined the doctor as PW. 2. The doctor has deposed that the claimant has suffered 13% permanent whole body disabilities. Considering the same, the tribunal has rightly assessed the whole body disabilities. Alla 7% taandidaralla. Whole body 13 no.
Total disability suffered is 40.25.
Vice. The whole body disabilities. Doctor has assessed whole body disabilities is 13%. The tribunal has rightly assessed the whole body disabilities is 13%. And rightly consider the multiplier 17.
Yes.
17. In respect of income is concerned, even though the claimant has claimed that he was earning 35,000 rupees per month, he has not produced any document to establish the same. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2012, the notional income has to be considered as 7,000. Accordingly, loss of future earning has been reassessed as follows. Lakh 85,000 reduction. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Yes. The compensation awarded by the tribunal in view of reduction of his monthly income, the loss of income during the later period has to be reduced to 21,000 against 27,000 awarded by the tribunal. In the other hand, the compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal in view of judgment of this court, the interest awarded by the tribunal is scaled down to 6% from 9%. Accordingly, the appeal is disposed of. ಯಾವ್ದು ಅವ್ರದ್ದು ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್ ಏನು ಯು ಆರ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್ ಈಸ್ ನಾಟ್ ಎನ್ ಅದು ಅವ್ರದ್ದು ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್. ಇವನ್ he further contended that the claimant has not suffered any injury in the road traffic accident, since the documents produced by the claimant, his name has been shown as Girisha Sheshgiri Rao. Sheshgiri. Other documents produced by claimant has shown as Girisha. ಅದೊಂದು ಕಂಟೆನ್ಷನ್ ಒಂದು ಮಾಡಿ. Yes. In respect of contention of the claimant regarding the name of the claimant is concerned, any document which has been produced to show that CH-Giri alias Girish. Paragraph 14 nalla. The tribunal, after considering that Aadhaar card and other documents, has rightly held that the claimant is CH-Giri alias Girish, who has suffered an injury in road traffic accident occurred on so and so date. Hence, the contention of the appellant is unsustainable. Adon paragraph. Yes. Injury. Yes, pass over. Vijay Kumar is not. Yes, Mr. Rajat. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದಾರಪ್ಪ?
Paragraph number 12. Before the petitioner is having permanent disability of 40% with respect to right leg and thigh. P11 case sheet and petitioner is having permanent disability of 40% with respect to right leg and thigh. One third of the disability is taken. Petitioner is having disability of 13.3 one body and rounded up to 13% is taken.
Yes, doctor ಅಷ್ಟು ಹೇಳಿದಾರಲ್ಲ. Where is that doctor evidence? After giving that evidence, he said it disability is 40%. ಹೋಗಿ ನಮ್ಮ ಆಸ್ಪತ್ರೆಗೆ 2 ಬಾರಿ ಚಿಕಿತ್ಸೆಗೆ ಒಳಪಡಿಸಲಾಗಿದೆ. ಮೊದಲ ಬಾರಿ ಒಳಪಡಿಸಿದಾಗ ಗಾಯ ಶುಚಿಪಡಿಸಿ ರಕ್ತನಾಳಗಳು ಬ್ಲಾಕ್ ಆಗಿದ್ದನ್ನು ತೆರವುಗೊಳಿಸಲಾಗಿದೆ. ಎರಡನೇ ಬಾರಿ ಮೂಲ
The certificate not for claim is that it is only laceration on the eye. There is also mentioned as simple injury. Since
it's it's in a deep this thing.
Yes.
They have assessed 40%. Otherwise, there is no fracture, nothing. ಜನಾಂಶಗಳ ಪರೀಕ್ಷೆ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಕೈಪಿಡಿ ಆಧಾರದ ಮೇಲೆ ಅದನ್ನೆಲ್ಲ ಆದ್ಮೇಲೆ ಡಾಕ್ಟರ್ ಸೆಡ್ ಈ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಕೈಪಿಡಿಯ ಆಧಾರದ ಮೇಲೆ ಗಾಯಾಳುವಿನ ಬಲಕಾಲಿಗೆ ಸಂಬಂಧಿಸಿದ 40% ಅಂಗನ್ಯೂನತೆ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಈ ದಿನ ರೋಗಿಗೆ ಸಂಬಂಧಿಸಿದ ಒಂದು ಒಳರೋಗಿ ಕಡತವನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಅದು ನಿವೇಶನ 1 ಎಂದು ಗಾಯಾಳು 2 ಎಕ್ಸ್ಟ್ರಾ ಹಾಜರುಪಡಿಸಿದ್ದು ನಮ್ಮ ಆಸ್ಪತ್ರೆಗೆ ಪೂರ್ವ ಗಾಯಾಳುಗಳು ವಯಸ್ಸು ಎಷ್ಟು ಕುಂಠಿತವಾಗಿದೆ, 50% ಕುಂಠಿತವಾಗಿದೆ. Yes, mister. Photos change ಮಾಡೋದು. Doctor evidence is more. Photos. Now we are not an expert to see what is the photos and all. Photos correct. ಇದನ್ನೇ ಅವ್ರು ಹೇಳಿರೋದು. ಮೇಲೆ ಸ್ಕಿನ್ ಎಲ್ಲ ಓಪನ್ ಆಗಿದೆ. Therefore, that skin has been healed. Scar may be there, but that will be healed. Lacerated wound alla, that will be automatically it will be cured. It is not any fracture which will affect your life throughout. Yes.
Still is up there 2016.
Yes.
9,000 ತಗೊಂಡಿದ್ದಾರೆ 9,500 after have been taken.
16 ಗೆ
Loss of abilities is also not awarded by the tribunal.
9,500 loss of
Abilities ಕೊಟ್ಟಿಲ್ಲ.
ಅಲ್ಲ ಇದು ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ sir.
9,000 ತಗೊಂಡಿದ್ದಾರೆ. It should be 9,000.
ತಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ 9,500.
9,500.
Yes. What is his claim?
This claim is 20,000 rupees as agriculture, 25,000.
25,000. Tribunal has taken 9,000.
9,000 ತಗೊಂಡಿದ್ದಾರೆ.
9,500.
Loss of abilities is not awarded.
Immunities is not awarded. Other head ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Okay. Page number 10.
Pain and suffering ಕೊಟ್ಟಿದ್ದಾರೆ. Medical loss of earning during ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ?
33 days.
Loss of income during the treatment, attendance charges.
Then charges, nourishment convenience, 18,500 total, 10,000 plus 8,500.
2 ತಿಂಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, 2 ತಿಂಗಳು. Doctors will make it notes for 3 months.
Yes, yes.
Difference between
Nourishment.
notes, additional will be 10,500 under the end of period.
Yes.
Loss of future earning capacity not additional will be 12,480. That rupees 9,500.
ಅಲ್ಲೂ ಇದ್ರಲ್ಲಿ ಒಂದು 93-27.
Amenities notes need to be awarded.
Amenities ಒಂದು 60,000 ಜಾಸ್ತಿ ಆಗ್ಬೋದು. Yes, mister. Interest ಎಷ್ಟಿದೆ?
Plus not 6% is awarded.
Yes. See, what's your name? Bhairarati. Bhairarati, learned counsel appearing for claimant has contended that at the time of the accident, the claimant was earning 25,000 per month. Tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 33 days. He has examined the doctor. Doctor has assessed the disability 40.
Respect of right leg and thigh.
Yes, assessed 40% disability in respect of right leg and thigh. The whole body disability is assessed by the tribunal. 13% is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, other incidental expenses is on lower side. The tribunal has failed to grant any compensation for future medical compensation for loss of amenities. Hence, he sought for enhancement of compensation. Per contra, the party learned counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 9,000 per month. He further contended that the injuries suffered by the claimants are minor in nature. Doctor has assessed the limb disabilities is 40%. The tribunal has rightly assessed the whole body disabilities as 13%. Lastly, he has contended that considering that evidence of doctor, considering that injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 16/12/2016 due to rash and negligent driving of driver of Bolero pickup bearing registration number KA 13 B 4885. Due to that extent, the claimant has suffered the following injury. He has examined Dr. Ramesh KT as PW2. In his evidence, he has deposed that the claimant has suffered 40% disability to right leg and thigh. While assessing whole body disability, the tribunal has considered 1/3 of limb disability and assessed the whole body disability is 13% is just and reasonable. Even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 35 years. The multiplier applicable to that age group is 16. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the above said injury. He was inpatient for a period of 33 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant has entitled loss of income during the later period for 3 months, and claimant is entitled loss of immunities for 50,000. Accordingly,
But there is no fracture only.
yes, we are not enhancing in other ground. Yes. Date of? What he wants next?
35 years ಇದೆ.
35 gets to multiplier. ಆಯ್ತು, ನೀವು ಕಮ್ಮಿ ಅವ್ರು ಜಾಸ್ತಿ ಅಂತಾರೆ, ಅದಕ್ಕೆ ನಾನು I said 50. Yes, 15 compensation awarded in other head are just and reasonable. Accordingly, the appeal is disposed of. Yes. Income tax returns filed. Yes, is a tribunal. What is the date of the accident? 2016. 11th ತಗೊಂಡಿದ್ದಾರಾ? ಯಾಕೆ 11th ತಗೊಂಡಿದ್ದಾರೆ? $22. Yes. ಅಲ್ಲ, ಎಷ್ಟಿದೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ದಿಸ್ ಥಿಂಗ್? ಅಲ್ಲ ಇದ್ರಲ್ಲೇನು ಎಷ್ಟು ಅಂತ ಹೇಳಿಲ್ಲ. ಮತ್ತೆ ಹೌ ದೇ ಕಮ್ ಟು ದಟ್ I can safely assess that notional income of the deceased is 11,000. 13 and 14 case of death ಯಾವಾಗ ಸತ್ತೋಗಿರೋದು? Date 4/11/2016. 4/11/2016 ಅಂತ ಅಂದ್ರೆ 16 ಅಲ್ಲೂ ನೀವು ಫೈಲ್ ಮಾಡಿರ್ತೀರಾ. 14, 15. Where is that 15, 16 then? ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲೇ ಗೊತ್ತಾಗೋದು 3 years average you can take it. ಜಾಸ್ತಿ ಇರೋದು ಎರಡು ಕೊಟ್ಟು ಬಂದಿದೆ ರೆಕಾರ್ಡ್ಸ್. $13, $14ಗೆ 1,81,580 gross total. 81,580. 1415. 20 lakhs. ಇಪ್ಪತ್ತು ಲಕ್ಷ ಇದು 18 ಲಕ್ಷ. ಅವರೇಜ್ ಎಷ್ಟಾಯ್ತು? 18, 20 ಎರಡು. 18, 20 ಅಂತ ಅಂದ್ರೆ 20, 38. 38 ಅಂತ 19 divided by 12.
Divided by 12. 15,833. 833.
Yes, Mr. Average at least 14,000 you have to take that. Yes. 14. Yes. ಯಾಕಂದ್ರೆ ಎರಡೇ ವರ್ಷ ಹಾಕಿದ್ದೀರ ಅದು. Yes. ಅದೇ there is an variation, then we can take that safely as 14. 3 years ಬೇಕು. Yes, 14,000 we can take. ಕೊಡಿ ಫೈಲ್ ಕೊಡಿ. Who are the claimants? Wife and son, daughter, married 36 years. 65 years, huh? Income tax. Future prospects ಕೊಟ್ಟಿದ್ದಾರಾ? 65, then there is no future prospects. Multiplier 7. Other head consortium. No, she is married. Daughter. Yes, daughter is entitled 40,000. Another 40 has to be added. Interest? Yes. Shri Tejas N. Learned Counsel appearing for claimant has contended that at the time of the accident, deceased was earning 50,000 per month. He was an income tax associate. He has produced income tax returns filed for 2013, 14 and 15. The tribunal has assessed the monthly income of the deceased as 11,000 is on lower side. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence he sought for enhancement of compensation. For contra, Shri B. Pradeep, Learned Counsel appearing for insurance company. Even though the claimant has claimed that he was earning 50,000 per month, he has produced income tax return for a year 2013 and 14 and 14 and 15. The relevant year for 15 and 16 he has not produced. Therefore, the tribunal has rightly assessed the notional income of the claimant as 11,000, deceased as 11,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There's judgment and award. It is not in dispute. Siddhappa died in road traffic accident occurred on 4/11/2016 due to rash and negligent driving of driver of tractor trailer bearing registration number KA 42 T6188. Even though the claimant has claimed that he was earning 50,000 per month, he has produced income tax returns for year 2013 and 14. The gross total is 1,81,580, and 14 and 15. The gross total income is 2,04,580. He has not produced income tax return for the year 2014 and 15 and 16. Taking into the consideration of average income tax, the monthly income of the deceased can safely assessed as rupees 14,000 per month. The tribunal has rightly considered the multiplier as 7 and deducted deduction 50% of the income of the deceased. Accordingly, loss of dependency has been reassessed as follows. Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled 40,000 for spousal consortium. The second claimant is entitled 40,000 for parent in consortium. Accordingly, the appeal is disposed of.
Somebody wants 2 weeks daily.
Yes, 2 weeks at the request of appellant, release this matter of 2 weeks. Yes. 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 How much? Yes, sir. That's it. How much tribunal has considered? 2017.
Another RDA could choose 5,000 per month was deposit.
ಯಾವಾಗ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿತ್ತು?
2017. Document shows some income was there, she was living that. She was working as a tailor.
4,000, 3,000.
details transactions. These are showing income proof. Notional income. Some higher income.
There is no proof how she got that income. She was not working.
Tailoring. Tailoring.
Tailoring ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇನೆ. ಅದಕ್ಕೆ ಏನು ದಾಖಲೆ ಇಲ್ಲ.
ಟೈಲರಿಂಗ್ ದಾಖಲೆ ಬೇಡ. ಇದೆ ದುಡ್ಡು ಕಟ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಸಿ ಮಂತ್ಲಿ ಅವರು ಲೈವ್ಲಿಹುಡ್ ಗೆ ಆಗಿದ್ರೆ ಎಕ್ಸ್ಟ್ರಾ ಕಟ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ ಈ ಮೋರ್ ದನ್ ದಟ್ ಈಸ್ ಅರ್ನಿಂಗ್. ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್ ಫಾರ್ ದಿಸ್ ಟೈಲರಿಂಗ್ ಆಮೇಲೆ ವೆಜಿಟೇಬಲ್ ವೆಂಡಿಂಗ್ ಅಂಡ್ ಆಲ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೆನಾಟ್ ಬಿ ಆಸ್ಕ್ಡ್ ಫ್ರಮ್ ವೇರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಿಲ್ ಗಿವ್. Who will give that? It is a self-employment. See, here he has produced that bank statement to show that some amount every month he is depositing, means after that livelihood, some amount has been deposited.
All the months,
All the months it is there. Some amount, that means to say, he is not in a daily wages like cooling. He is doing some work and earning.
Page 8, it is clearly.
Yes, where is that discussion of the tribunal? Yes. Yes. Indisputably, petitioners are the children of the deceased. Documents marked exhibit Reach is the proof. As already pointed out, 15 years she has specialized in stitching and he was earning not less than 20,000 per month. No, she's a lady, woman. Husband is there.
Husband is there and 3 daughters.
Yes.
Each of my daughters 7 years old. They lost their mother.
2000, huh? No, 2017. What is that? 11,000.
11,000.
I can expect this placing some material to show that she was saving the income.
No, that's even that notional income is 11,000. Your income, you are saving that income 5,000, 8,000 per month. 1,000. That means you are earning 11,000. If you take it 11,000, you can save that 8,000. Since you are in a house, the lady, if it is an, therefore I thought that he is an husband. Husband means he has to spend the entire family. His husband may be maintaining the family. Your income should be only 8,000. If you take it that, it is not 11,000. Yes, we will consider. Yes. No, that's no. If you go taking to the consideration, since she is a housewife, it cannot be taken 11,000. Then you can rely on the document show that she is earning.
Yes, the statement also balance stood in the state.
That means to say all our income has to be kept in that bank.
Document to show that how she earned that money.
That is, she is doing tailoring, sir. That is not illegal. Other that they cannot produce.
ಬೇರೆ ಅವರ ರಿಲೇಟಿವ್ಸ್ ಫಾದರ್ ಮದರ್ ಯಾರಾದ್ರೂ ಕೊಟ್ಟು ಅದನ್ನು ಸೇವ್ ಮಾಡ್ಕೊಂತಾ ಇರ್ಬೇಕು.
That is the income. Yes.
They should suggest like that this income is not an investment. Somebody else has given me. There should be some cross-examination. Yes.
I will consider. Yes. What is that age?
32 years.
Future prospects kotilva 40%.
Conventional consortium was awarded 40,000.
1/3 has been deducted, right? Yes.
Consortium only 40,000 was awarded.
That will consider as per the Supreme Court. Yes, that's all. Shri Ravi Shankar Shastri, Learned Counsel appearing for the claimant, has contended that at the time of the accident, deceased was earning 20,000 per month by doing tailoring work. The tribunal has considered the notional income of the deceased as 9,000 per month is on lower side.
He contended that through that income of the deceased, they have produced bank statement as exhibit P18 to P20 to show that every month she is depositing some amount in her SP account and RD account in post office, sir. In State Bank of India and post office saving bank account, RD account in post office. He further contended that in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for what is that interest awarded, Mr.
6%.
Insurance company has contended that even though the claimant has claimed that she was earning, claimed that deceased was earning 20,000 per month by tailoring, the bank statement which they have produced, which shows that she has income of rupees 8,000. In some months, she has deposited 5,000. Therefore, the notional income assessed by the tribunal, 9,000 is just and reasonable. He further contended that since the claimant has failed to establish her income, the tribunal has not granted future prospects. Lastly, he has contended that considering the age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. What is the name of the deceased? Shanti S. died in road traffic accident occurred on 2/8/2017 due to rash and negligent driving of driver of lorry bearing registration number KA19C7884. The claimant has claimed that deceased was earning 50,000 per month, the 20,000 per month by doing a tailoring work. They have produced exhibit 18 to 20. Exhibit 18 to 20, the passbook related to the State Bank of India and RD account related in post office. It shows that the deceased was saving some amount and she is depositing in the bank. Considering the same, even as per that notification issued by, as per the guidelines issued by Karnataka Legal Service Authority for the accident occurred in 2017, the notional income has been fixed as 11,000. Under those circumstances, in my opinion, the notional income of the deceased can be assessed as 11,000 per month. In view of judgment of apex court in case of Pranay Sethi, since deceased was aged about 32 years, 40% of the income of the deceased has to be added for future prospects. The tribunal has rightly deducted 1/3 of the income of the deceased for personal expenses. The multiplier applicable to the TH group is 16. Accordingly, loss of Dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled 40,000 for spousal consortium, 2 and 3 entitled 40,000 each for parental consortium. Accordingly, the appeal is allowed. Yes. In part, judgment and award passed by the Supreme Court. Yes, Mr. Vijay Kumar. Yes. 2014. Yes. Hmm. 14. 20,000 per month. Yes. So, income tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 6,000. Where is that? Early the discussion of the tribunal. Wherein the name of person has shown on license to run the hotel business and income tax returns. However, in that cross-examination is admitted that hotel business license producers could have been renewed. He has not renewed that said license, therefore said document evidence. Yes, where is that income tax return? Early documents early the income tax returns. Documents ಬಂದಿದ್ಯಾ? Income tax returns ಎಲ್ಲಿದ್ದಾರೆ? ಇದೆಯಾ? What is the date of the accident? 14. Yes, he has produced that. What is his name? Harish Gowda. Yes, he has producing that income. 10, 11, 11, 12, 12, 13. Yes. 13, 14 area. 13, 14. Yes. Whether the license may not be renewed, but he has an income that has to be considered. The 3 lakhs. As in the date of the accident? 2 lakhs. 2 lakhs. What of that? Into divided by 3. Two lakhs divided by 2 and 3 lakhs. Divided by 2 lakhs divided by 12. 16,666.
Two lakhs. 16,666.
What is the income tribunal has taken?
Yes.
Hotel business and close ಆಗಲ್ಲ, hotel business running ಆಗಿದೆ. Hotel ಮಾಡ್ತಾರೆ ಅದನ್ನ close ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ.
Yeah, hotel business ಇರ್ಲಿ ಏನೇ ಇರ್ಲಿ, but he has paying that income tax, but he has an income, is it not? ಎಂತದ್ರಲ್ಲಾರ ಪೇ ಮಾಡ್ತಿದಾರ, we don't know, but he has paying that income tax. That has to be considered. Insurance license renew ಆಗಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ his income tax has to be decided. Yes. Then what is the disability? 30%? Tribunal 10% ತಗೊಂಡಿದಾರ? 30 into 10 correct ಇದೆ. Yes. ಆಯ್ತು, is in a case of injury, what is that 2016 ಅಲ್ಲ 14-15, it's a case of injury, Mr. I am just thinking about that death. Accident ಆಗಿರೋದು ಯಾವತ್ತಲ್ಲಿ? 14. Income tax ಯಾವ ವರ್ಷಕ್ಕೆ ಹಾಕಿದೀರಾ? What about that 15? What is that income in 15 you produce? That shows you are not entitled for that future loss of income, Mr. I thought that it is a debt case. You have no loss of income, you have continued. Yes, yes, we will take that notional income and discuss. Pain and suffering 40 ಕೊಟ್ಟಿದ್ದಾರೆ, medical expenses as it is, food and nourishment 20 ಕೊಟ್ಟಿದ್ದಾರೆ, food and nourishment incidental expenses, loss of income during the treatment. How many days you were in the hospital? 11 days. 6 ತಗೊಂಡಿದ್ದಾರೆ, 2 months ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of income due to that permanent disability. ಆಯ್ತು. Disappointment, amenities ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಬೇಕು. Further medicals, interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 9%. Yes, that's all. So and so, learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 20,000 per month by doing an agriculture and business. The tribunal has assessed notional income of claimant as 6,000 per month is on lower side. He further contended that due to that extent, the claimant has suffered previous injury. He was inpatient for a period of 11 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, the pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence he sought for enhancement of compensation. For contra, Sri B. Pradeep, learned counsel appearing for the insurance company, has contended that even though the claimant has claimed that he was earning 20,000 per month and he has produced income tax returns, it shows that there is no loss of income due to the disability. Therefore, the compensation assessed by the tribunal for loss of income due to the disabilities is just and reasonable. He further contended that due to that extent, Further contended that considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, perused judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 18/9/2014 due to rash and negligent driving of rider of motorcycle bearing registration number KA 13 S5376. Due to that accident, the claimant has suffered the following injury. Considering that injury suffered by the claimant and considering that evidence of doctor, the tribunal has rightly assessed the whole body disabilities 10%. Even though the claimant has claimed that he was earning 20,000 per month, he has produced income tax returns. He has not produced income tax returns after that accident to show that he has suffered any loss. Under the circumstances, the tribunal has rightly assessed the notional income of the claimant. While assessing the notional income, the tribunal has considered 6,000 per month is on lower side. In view of guidelines issued by Karnataka Legal Service Authority for the accident occurred in 2014, the notional income has to be considered as 8,500. The multiplier applicable at the time of the accident, he was aged about 31 years. The multiplier applicable to the age group is 16. Accordingly, loss of future earning has been reassessed as follows. Due to that extent, the claimant has suffered the following injury. He was inpatient for a period of 11 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for loss of income during the later period for 3 months. Loss of immunities from 10,000 to 30,000. Loss of the diet, nourishment and conveyance charges has to be enhanced from 20,000 to 25,000. The enhanced compensation amount carries 6% interest. Accordingly, that will be. Yes, Vijay Kumar is not there from morning. What is this, Mr. Only announcement? Yes, pass out. Next week. Yes, Friday. Friday, not interested in afternoon. Yes. At the request of parties, release this matter next week. Nayak Krishna 56 ಯಾಕೋ ಅರ್ಜನ್ ಆಗಿದೆ ಯಾರ ಬಗ್ಗೆ ಎಂ ವೆಂಕಟೇಶ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ ನಿಮ್ದ್ರಲ್ಲಿ ವಿಲ್ ಟೇಕ್ ನೋಟಿಸ್ ಇನ್ ಪ್ರದೀಪ್ number 1 ಈ ಪ್ರದೀಪ್ is directed to take notice for respondent number 1. What about 2, Mr.
Kindly notice to be dispensed with.
Dispense notice to 2. Yes, ready. ಏನಕ್ಕೆ ಅಲ್ಲ ಏನು ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ ನೆಗ್ಲಿಜೆನ್ಸ್ ಎಸ್ ಹಾರ್ಡ್ ಅಡ್ಮಿಟ್ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ತಾವ ಯಾವ ಹಿಯರಿಂಗ್ ಇಲ್ಲ ಹಂಗಾಗಿ next week you are not there.
and list this matter on 19th. 19. Yes. Yes, Palakshay, but here, pass out.
In this case, I applied for appointment, my lord. Pray for a week's time, my lord.
Why?
In this case, there is a pay and recovery order is there due to oversight. I dispense the notice to R2. I have to take the steps to R2.
Just there is this matter of 2 weeks.
Much old.
61, somebody has taken time, Mr. TG. ಯಾವುದು ಹೇಳಿದ್ದಾರೆ ಸನತ್ ಕುಮಾರ್ ಬಸವ್ Third, issue notice. The net counsel for the appellant has filed a memo for dispensation to R2 is notice to dispense at the risk of the appellant. Issue emergent notice to respondent number 1. Password. Yes, ready. Password. Yes. On what ground you are challenged? Ellie. Then the tax rate is occurred. You read the issue number 1. Slowly.
Yes, what is your case? Medical, when that complaint has been lodged? Medical records ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ? MNC extract ಕೊಡಿ, exhibit T12. At MNC extract. Below black. Ingaya, son of cell fall from the bike when dog came and yes, correct. They are not claiming that the other vehicle has come and hit. Rider of the motorcycle has, rash and negligent. It is a comprehensive policy, therefore they are claiming. Is it not? Self fall antane. They are not claiming that any other vehicle has. They are entitled for compensation. Is it not under 166? Where is that complaint? It was a pillion. Yes, pass out. Afternoon. Any Pradeep is coming afternoon. Yes. Yes. Huh? Yes, yes, yes. Liability dispute ಏನಾದ್ರು ಇದೆಯಾ? Then you can appear. Alla. 1 and 2 are jointly and severally. There is no dispute regarding that liability. It's a case of death. Yes. What is the dispute? We can appear for Shivanegoda. Yes. Yes, Mr. Counsel. What is your case? What is the date of the accident? 2018. Signal 9,000 ತಾಂಡಿದಾರಾ? 2018 accident, 12,500. What was his age? Early the discussion income ಬಗ್ಗೆ signal.
Page number 24.
Page number?
Page number 24, para number 59.8. Income, page number 8 of the chapter. Yeah, well done.
Page number? Funeral expenses, so as per the conventional and ಏನ್ರಿ ಇದು ಏನೇನೋ ಸಿಕ್ಕಾಪಟ್ಟೆ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳೆಲ್ಲ ಕೊಡ್ತಾರೆ. 9,000 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನ್ರಿ ಫೈಂಡಿಂಗ್?
Page number 8.
Page number 8, yes. No petitioner has conducted 30,000 working as a vendor, no material has been produced, 9,000 ಆಯ್ತು. Where is that, have they consider for this thing, future prospects? What is the future prospects?
25%,
52 years.
Page number 25, 25.
ಏಜ್ ಎಷ್ಟು? 52 years ಅಂದ್ರೆ 15% ಹೆಂಗ್ ಬರುತ್ತೆ?
10%. Criminal 15 ತಗೊಂಡಿದ್ದಾರೆ. 10% ತಗೊಂಡಿದ್ದಾರೆ.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇದೇ ಸ್ಟ್ಯಾಂಡ್ ಇದ್ದಾರೆ 11 ಅಂದ್ರೆ ಎಷ್ಟಿದೆ? 11 ಅಂದ್ರೆ 51 years, 52 years ಮಿಸ್ಟರ್.
Yes, ma'am. ಅದು ಇನ್ಕಮ್ ಚೇಂಜ್ ಆಗುತ್ತೆ 12 ವರ್ಷ.
will have to be 6,000. ಎಲ್ಲಿದೆ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಡಿಸ್ಕಷನ್ ಎಲ್ಲಿದ್ದಾರೆ?
ಡಿಸ್ಕಷನ್ ಏನಿಲ್ಲ ಸರ್.
ಹೆಂಗೆ ಡಿಸೀಸ್ಡ್ ವಾಸ್ ಮೋರ್ ದೆನ್ ಏಜ್ ಆಫ್ 50 years ಅನ್ಬಿಟ್ರತ್ತೆ. Forty to 50, then where the deceased between the age of 50 and 60 ಅಂತ ಹೇಳ್ಬಿಟ್ಟು 15 ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ. That is while determining the income of additional 50 to 60, that is permanent income. Yes. What of the 12,500. 1/3 deduction ಅಲ್ಲ? 10%. That's 10,042. Yes, Mr. 10% ಆಗುತ್ತೆ, 15% ಅಲ್ಲ. Yes, in
9%.
interest. Yes, yes. What about that consortium? Consortium ಎಷ್ಟು ಕೊಟ್ಟಿದಾರಪ್ಪ? Who are the claimants?
Wife and daughter.
2 daughters. Funeral expenses. ಅದು ವೇರಿಯೇಷನ್ ಆಯ್ತು. ವಿಲ್ ಕನ್ಸಿಡರ್. Abhijit MM, Learned Counsel appearing for the claimant has contended that at the time of the accident, deceased was aged about contended that at the time of the accident, deceased was earning 30,000 per month. The tribunal has assessed notional income of the deceased as 9,000 per month is on lower side. He further contended that in view of judgment of apex court in case of magma, the claimants are entitled 40,000 each. Hence he sought for enhancement of compensation. Per contra, Shivanegowda Learned Counsel was there in that hospital. Then he has died. Mr. Learned Counsel appearing for insurance company has contended that even though the claimant has claimed that deceased was earning 30,000 per month, They have not produced any document to establish the same. Therefore, the tribunal has rightly assessed notional income of the deceased as 9,000 per month. He further contended that at the time of the accident, deceased was aged about more than 50 years. Since they have failed to establish their income, tribunal, instead of adding 10% of the income of the deceased for future prospects, they have calculated 15%. Has wrongly calculated 15%. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Perose, judgment and award. It is not in dispute. The claimant has suffered. The claimant has died in road traffic accident occurred on 15/6/2018 due to rash and negligent driving of driver of Tata AS vehicle bearing registration number KA15A1208. Even though the claimant has claimed that he was earning 30,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2018, the notional income has to be considered as 12,500. The tribunal has assessed the age of the deceased as more than 50. Therefore, in view of judgment of apex court in case of MAGMA, 10% of the income of the deceased has to be added for future prospects. The multiplier applicable to that age group 51 to 55 is 11. Since there are 3 dependents, 1/3 of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of MAGMA, first claimant is entitled 40,000 for spousal consortium, 2 and 3, 40 each for parental consortium. Enhanced compensation amount carries 6% interest. ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೀವಿ 40,000 each ಕೊಟ್ಟಿದ್ದೀವಿ. Yes. Yes, Siddesh. Yes.
Fracture of right is single.
Yes.
Fracture of right femur.
2015.
2015 is the accident. Fracture of right femur, right tibia, fibula, and amputation of right middle toe.
Yes.
The future injury, future income is denied. Solely on the ground that Malad appellant examined PW2 that one Nagabhushi. He was not yet treated. That is the reason.
What is the disability he has assessed?
42% disability is assessed for all these only.
ಶೇಕಡ 42% ಆಗಿರುತ್ತದೆ.
So the amputation is the right ತಗೊಂಡು 42% assessment.
What is that amputation? Workman compensation.
No, it is amputation of right middle toe.
ಅಂತ ಹೇಳಿದಾರಾ ಡಾಕ್ಟರ್?
Doctor ಹೇಳಿದ್ದಾರೆ. Yes, sir.
Not treated the
Wait,
document.
wait, I will hear you, mister. Let him complete. ಇದಲ್ರಿ. Wait, wait, wait. Yeah, disability middle finger,
Amputation of right middle finger. It should go on there.
Go.
Go. Last P19. Paragraph 13 ಇಂದ ಶುರುವಾಗುತ್ತದೆ.
Yes. Yes, it is. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ?
Disability certificate ಅಲ್ಲಿ. Practice exhibit P19.
So amputation ಆಗಿದೆ ಅಷ್ಟೇ.
Amputation of amputation ಇಲ್ಲ ಅಂದ್ರೆ a fracture of right femur, right tibia and fibula and amputation of right middle toe. And 42% he has assessed 42%. That is not taken into consideration.
ಆಯ್ತು told other than the grade go it is only 3%.
Other than the ಇದರಲ್ಲಿ 42% ಅಂತ ಹೇಳಿದೆ.
ಅಲ್ರಿ ಬರ್ತೀನಿ ಟೋಗೆ as per that this thing 3%.
Indian right femur, tibia and fibula.
42% 1/3 ತಗೊಂಡ್ರು ಕೂಡ 12% ಬರ್ತದೆ. 14 ಹಿಂಗ್ ಬರ್ತದೆ. 15 ಮೂರನೇ 45 14 ಆದ್ರೆ 14 ಮೂರನೇ ಎಷ್ಟಾಯ್ತು? 28 42. Yes, 14%. 14%. Yes. Why the tribunal has not considered?
ಅದು ತುಂಬಾ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ದಾರೆ. Paragraph.
What was he?
He was
Puni. Then disability. He is not continued any other work. Doctor has said 42, at least 14%. Yes. What is his income?
ಮೇಸನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಮೇಸನ್ ಅಂಡ್ ಅರ್ನಿಂಗ್ 10,000.
ಅಲ್ಲ ನಿಮ್ದು ಎಷ್ಟು ಹೇಳಿದ್ದೀರಾ ನೀವು?
9,000 ಅಂತ ಹೇಳಿದ್ದೀವಿ.
2015 ಗೆ ಎಷ್ಟಿದೆ?
9,000.
That's all right. Tribunal, yes, how many days you were in the hospital?
He was there in the Mumbai hospital. 27 days. Inpatient.
Yes.
ಅಷ್ಟಿದ್ರೂ PW2 ನಾಟ್ treated ಡಾಕ್ಟರ್ ಯಾರನ್ನ ಬರ್ಕೊಂಡು
ಆಯ್ತು.
ಅದಕ್ಕೆ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಯಾಕಂದ್ರೆ 6035 ಅಲ್ಲಿ ಡಿಸ್ಚಾರ್ಜ್ ಆಫ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಲೆಟ್ ಅದು
Yes, I have seen that.
ಹೌದು ಅದು ಗೊತ್ತಿದೆ
Yes.
ಅದಕ್ಕೆ ಅದು ದಟ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ ದಿ ಡಾಕ್ಟರ್ ಆಮೇಲೆ ಇದರಲ್ಲಿ
Payments of
25,000
loss of immunities ಕೊಟ್ಟಿದ್ದಾರೆ, medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Loss of income. That will consider what is that interest awarded?
6% ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಬರೀ 8,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಟ್ಲೀಸ್ಟ್ 3 ತಿಂಗಳು ತಗೊಂಡ್ರು 27,000.
How many days you are in the hospital?
27 days.
Yes. Yes, that's all. Yes, Mr. Vijay.
PW2 is not treated doctor in
Will consider. Yes. See, Siddheshwara NK.
after 35 days delaying complaint.
ಅಲ್ಲ ಅದನ್ನ ಮಾಡಿ
Then challenge ಮಾಡಿಲ್ಲಲ್ಲ ನೀವು.
ಟ್ರೆಡಿಷನಲ್ ಆರ್ಡರ್
ಏನಂತ?
ಅದನ್ನ ತಗೋಬಾರ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಆಗ್ತದೆ
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಕಂಪ್ಲೇಂಟ್ ಡಿಲೇ ಇನ್ ಲಾಡ್ಜ್ ಅವ್ರೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲಲ್ಲ.
ಸ್ಯಾಟಿಸ್ ಮಾಡಿದ್ರೆ ತಗೋಣ
ಶ್ರೀ Siddheshwara NK Learned Council appearing for insurance company, the claimant has contended that at the time of the accident, contended that due to that accident, the claimant has suffered grievous injury. He has examined the doctor. Doctor has deposed that there is an amputation of right third toe, and he has assessed, and there is a fracture of right femur, and he has assessed permanent disability of 42%. Due to the disability, the claimant is unable to do his day-to-day work. The tribunal has failed to grant any compensation for loss of future earning. He further contended that due to that extent, the claimant has suffered grievous injury. He was inpatient for a period of 6 days, 27 days. He has suffered a lot of pain during the treatment. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Lastly, he has contended that at the time of the accident, the claimant was earning 10,000 per month. The tribunal has considered the notional income of the claimant as he was earning 10,000 per month. The tribunal has considered 8,000 tandidaralla last. Has considered the notional income of the claimant as 8,000 per month is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri Nagarajaya K. Learned Council appearing for insurance company has contended that the injuries suffered by the claimants are minor in nature. He has examined the doctor who is not a treated doctor. Due to that injury, there is no loss of income to the claimant. Therefore, the tribunal has not awarded any compensation for future loss of income. He further contended that due to that extent, the injuries suffered by the claimants are minor in nature. He was inpatient for a period of only 27 days. Considering the evidence of doctor and injuries suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. And in respect of income, he has contended that even though he has claimed that he was earning like 10,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 12/3/2015 due to rash and negligent driving of driver of which vehicle? What is that vehicle? Motorcycle bearing registration number KA14 EC 2984. Due to that accident, the claimant has suffered the following injury. He has examined Dr. Nagabhushan as PW2. In his evidence, he has deposed that the claimant has suffered the fracture of right femur and his right third toe has been amputated, and he has assessed the permanent disability of 42%. Considering that evidence of doctor and considering that injury suffered by the claimant, I am of the opinion that the whole body disability has to be assessed 14%. Due to the disability, the claimant is unable to do his day-to-day work. Hence, he is entitled for loss of income, loss of future earning due to the disability. Even though the claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority for the accident occurring in 2015. The notional income has to be considered as 9,000. At the time of the accident, he was aged about 20 years. 20 years. The multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as per. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 27 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 35,000. Loss of income during the later period has to be granted for 2 months. The compensation awarded by the tribunal in the other hand are just and reasonable. In view of order dated 21/3/2022, is not entitled for the interest for a period of 135 days. Accordingly, the appeal is over. Yes. Yes. Two thirty will do. Forty-six ಏನಾಗಿದೆ? Who is appearing for that? Where is he? ಏನಾಗಿದೆ? ಪಾಸ್ ಹೊರಗೆ. ಯಾಕೆ why not? What is that? No, he has. No, he said entire liability has to be on the insurance case. Yes. Where is he? 230. No, it is already written. Next week. Yes. Next week. Next week ಒಂದು ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ. ಅವ್ರಿಗೆ ಒಂದು ಮೆಮೊ ಕೊಡಕ್ಕೆ ಹೇಳಿ. Then we have written that admit call for next week, the hearing. Yes. Serial number 58. 58 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಎಸ್ ಮಿಸ್ಟರ್ ಇವರೆಲ್ಲ ಇದ್ರು. You are appearing for respondent. ಏನಾಗ್ಬೇಕು? What you want? You want the records is already there. You want 2 weeks time? Yes, sir. The request of counsel for respondent. Release this matter after 2 weeks. 40? ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ? ವೈ? Yes, the request of the parties to release this matter next week. Yes. Yes. ಬರಲ್ಲ.
ಒಂದು ಎರಡು ಇದು ದೇವಣ್ಣ Part 4 matter, number 2. Serial number 32. Ramesh Share for appellate, be ready.
Yes.
Yes, sir.
Yeah. 32. Yeah. Yes. 2000. Yes. Yes. Hmm. Yes. Yes. Hmm. Yes. What is that evidence of the doctor? Records ಬಂದಿದ್ಯಾ? Check the records. Yes. Head injury following the road traffic accident so and so. Assessment to a neuro social equipment, moderate disability, 100% disability. Assessment with the physical, social work, social disability, moderate disability. Consumer complaint. ನಾನು ಅರ್ಜಿದಾರರಿಗೆ ಯಾವುದೇ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. Alada, he is not treated doctor. The doctor who has treated him. ಅಲ್ಲ ಮಾಡಿಲ್ಲ, ಯಾರು ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೋ? Who has? ಗಾಯಾಳುಗಳು ಮೊದಲ ಬಾರಿಗೆ ಆಸ್ಪತ್ರೆಯಿಂದ ಬಿಡುಗಡೆಯಾದಾಗ ದೇಹಸ್ಥಿತಿ ಉತ್ತಮವಾಗಿತ್ತು ಅಂದರೆ ಸರಿ.
ದೀಪ್ತಿ ರಂಜನ್. Assessment of neurorehabilitation, Department of Locomotor Disability cannot be assessed ಅಂತ ಹೇಳ್ತಾರೆ.
Neurological social equipment.
Nerve, sensor motor defects, no bladder involvement, no cerebral signs. And stable condition ಇದ್ದಾರೆ ಅಂತ ನೀವು ಹೇಳ್ತೀರಿ.
When he was discharged.
ಹೌದು, ಸ್ಟೇಬಲ್ ಕಂಡೀಷನ್ ಇದೆ ಅವರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. For further observation on 24/4/2016 in a stable condition.
ಇಲ್ಲಿ
ಅವರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಲಾಸ್ಟ್ ಲೈನ್. She was discharged to the general hospital for further observation on 24/4/2016 in a stable condition.
Yes. What is the discussion of the tribunal?
30% ತಗೊಂಡಿದೆ. Discussion internal page 19.
What is that age of the climate?
44 years. 44 ಅಂತ.
What is his name? She is not able to retire. 40 years as of their practical age is shown that 44 years.
Internal case sheet and 44 years.
ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ? She don't have any documents. Why? That is See, if it is a rural villagers, even now you can produce that. That shows that you are suppressing. Is it not? Voters list. Yes, therefore tribunal has taken 44. See, wound certificate, medical certificate is not a correct date of birth. If you really have any date of birth, even now you can produce that. She is in a tailor. Voters list irutte, Aadhaar card ide. Compulsory. No, you can't say. No, the intention is the inference has to be drawn that you are suppressing that. Otherwise, you could have produced now also. Therefore, you have to take 44 only, since he has not challenged. Yes. 30,000. How many days you are in the hospital? Yes. 15 days. Medical expenses. What is there? Food and nourishment, attendance charges, loss of income during the later period. What is the income tribunal has taken? 9,500. 500. ನೀವು ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ? Future earning, loss of amenities. Future medical expenses ಏನು ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ. Even doctor has also not said.
Stable condition is another.
Yes. No, he said she further underwent bone flap replacement surgery on 18/7/2016.
One flap.
Yes, that is before discussion of the tribunal. Then I think it is added in the medical expenses. Just quoted the medical expenses.
74,450.
Yes. But however, looking into the nature of the injury and medical evidence, disability to whole body petitioners is assessed 30%. Assessed she has 40 years. Assessment neurological, social equipment, and rate 100% disability. Yes. Yes, that's all. Yes, Mr. Puri. Yes, we'll consider. Sri, what's your name? Sunil? Sunil KN. Bernard Council appearing for. The claimant has contended that due to that extent, the claimant has suffered grievous injury. Doctor has been examined as CW1. In his evidence, he has deposed that the claimant has suffered assessment by neuropsychological social quintet 14.14 moderate disability 100%. Since the claimant has suffered a head injury, she was unable to do his day-to-day work. She was not in a position to give any evidence. On her behalf of her husband has given evidence as PW1. The tribunal has failed to consider functional disability. He further contended that the tribunal has only assessed the disability of the claimant is 30% is on lower side. He further contended that at the time of the accident, the claimant was earning 15,000 per month, working doing as a tailoring. The tribunal has assessed notional income of the claimants as 8,000 per month is on lower side. He further contended that due to that extent, the claimant has suffered grievous injury. She was inpatient for a period of 15 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. The compensation heads he sought for enhancement of compensation. The compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri B. Pradeep, learned counsel appearing for the insurance company, has contended that even though the claimant has suffered a head injury at the time of the discharge, she was stable, the condition was stable, and she was fully recovered from the injury. It is very clear from the evidence of the doctor that when she was discharged from the hospital, she was stable, the condition was stable. Therefore, considering that evidence of doctor and considering that injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities as 30%. Even though the claimant has claimed that she was earning 15,000 per month, she has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that the tribunal, considering that evidence of doctor and injury suffered by the claimant, has granted a just and reasonable compensation. The compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses are just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 18/4/2016 due to rash and negligent driving of driver of car bearing registration number KA 52 M2644. Due to that accident, the claimant has suffered the following injury. Dr. Abhinita Sheshidhar has been examined as CW1. In her evidence, she has deposed that mark ಮಾಡಿದೆ. And she further submitted that when that claimant was discharged from hospital, the condition was stable. Considering that evidence of doctor, considering and due to that injury, she was unable to give any evidence. Considering the same, I am of the opinion that the whole body disabilities can be assessed 40%. Even though the claimant has claimed that she was earning 15,000 per month, she has not produced any document to establish the same. Therefore, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, she was aged about 44 years. The multiplier applicable to the age group is 14. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the above said injury. She was inpatient for a period of 15 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, considering that injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000 for loss of income during the later period has to be granted for 3 months. Loss of amenities has to be enhanced from 40,000 to 50,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, the appeal is allowed in part. Judgment and award part by the tribunal is modified as delay of 250 days is condoned. IA 1 of 20 is allowed subject to not entitled for the interest. Not entitled for the interest. Dispense notice 1 and 2. Yes, office, the tribunal is directed to release that enhanced compensation amount in favor of the claimant after due verification.
Serial number 45, file number DPD.
Yes. 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 7/3/2019. 16 at 2:30 PM. Yes. Yes. Oh, is a case of injury. No, which hospital you have? Yes, you got MLC extract.
Exhibit we can discuss. Exhibit
MLC P18.
P18.
Why the tribunal has dismissed? Madam? Delay, but the complaint is against that offending vehicle only. Only because the delay. No, that there is no dispute, Mr. Pradeep, involvement of the vehicle.
Involvement of the vehicle ಅಂತಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿಸ್ ಇದೆ. ಅವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ರದರ್ 17ನೇ ತಾರೀಕು 17/9/2016 ಜನಪ್ರಿಯ ಹಾಸ್ಪಿಟಲ್ ಇಂದ ಪೊಲೀಸ್ ಅಥಾರಿಟೀಸ್ಗೆ ರಿಗಾರ್ಡಿಂಗ್ ಹಿಸ್ಟರಿ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಂಟಿಮೇಷನ್ ಕೊಡ್ತಾರೆ.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅವತ್ತು
ಸೇಮ್ ಡೇ ಕಂಪ್ಲೇಂಟ್ ಪೊಲೀಸ್ನವರು
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದ ಡೇಟ್ ಯಾವತ್ತು?
6/17 ಕಂಪ್ಲೇಂಟ್ ಆಗಿದ್ದು 19/9
2:30 3:25 ಗೆ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದಾರೆ. What is that RTA on so and so round of 2:30 near that MG Road, Hassan? Yes, it is on that on the same day it is reported.
Same day ಹೋಗಿದ್ದಾರೆ. They knows very well the owner of the vehicle has given assurance that he will bear the medical expenses. They have not mentioned regarding the vehicle number there. And in the MLC extract and the MLC hospital authorities, moreover, they have not disclosed that which vehicle has met with an accident. And his brother has given a update. Moreover, that the hospital
not mandatory.
Hospital authorities intimation ಕಳಿಸ್ತಾರೆ regarding accident ಅಂತ ಹೇಳಿ 17ನೇ ತಾರೀಕು. But 17ನೇ ತಾರೀಕು police authorities ಬಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ, ಸ್ಟೇಟ್ ಮಾಡಲೇನಿಲ್ಲ. 2 days ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ.
Where is that report? One thing is, wait, madam. One thing is, she suffered injury in road traffic accident. Only thing is that which is the vehicle which is involved, is it not? Now that because day one they have admitted the hospital, it is mentioned that RTA. Where is that police intimation?
Police intimation exhibit P2 ನಲ್ಲೂ vehicle number ಹೇಳ್ತಾರೆ.
Vehicle number ಹೇಳಿದಾರ?
ಹೇಳ್ತಾರಲ್ಲಿ ಪೊಲೀಸ್ನವರು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಅಂತ ಅದೊಂದು. ಆಮೇಲಿಂದ ಬ್ರದರ್
I thought that even that intimation they have sent only that intimation vehicle.
Police station
it is more than enough.
Police station intimation ಹೋಗಿದೆ. We have not adduced any evidence and serious dispute ನಾವೇನ್ ಮಾಡಿಲ್ಲ.
Then what is the finding of the tribunal?
Tribunal ಅವರು ಅದೇ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿಸ್ ಇದೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಒಂದು ಬ್ರದರ್ ಮಂಜೇಗೌಡ ಅನ್ನೋರು brought the petitioner to the said hospital and mother of the petitioner, namely Shailaja, has been affixed as signature by contesting the surgery. Authorities ಆಮೇಲಿಂದ ಸಂಜಯ್ ಗೌಡ does not find place in any hospital records to substantiate the version of the petitioner ಅಂತ ಹೇಳ್ತಾರೆ. Exhibit ಮಂಜೇಗೌಡ ಅಂತಿದೆ. ಅವರಿಲ್ಲ
ಮಂಜೇಗೌಡ ಇನ್ನು ಎಕ್ಸಾಮ್ ಮಾಡಿ
ಮಂಜೇಗೌಡ ಅನ್ನೋರು ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಟಿರಲ್ಲಿ. ಇಲ್ಲಿ ಇದರಲ್ಲಿ ಬಂದಾಗ the name of the ಸಂಜೀವೇಗೌಡ does not find place in any hospital record. ಸಂಜೀವೇಗೌಡ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರು ಹೇಳದ್ ಸಂಜೀವೇಗೌಡ ಅಂತ? ಸಂಜಯ್ ಗೌಡ ಹಾಸ್ಪಿಟಲ್ ಕರ್ಕೊಂಡು ಹೋದ ಅಂತ. ಹಾಸ್ಪಿಟಲ್ MLC ಏನಂತ ಇದೆ? Who has brought?
ಮಂಜೇಗೌಡ.
ಅಂಜೇಗೌಡ ಯಾರು?
ಅಂಜೇಗೌಡ ಯಾರು ನೇರು?
ಹ್ಮ್.
ಸಂಜೀವೇಗೌಡ ಅಂತ.
ಅವ್ರು ಹೇಳುವಾಗ ಸಂಜೀವೇಗೌಡ ಕರ್ಕೊಂಡೋಗಿಲ್ಲ, ಮಂಜೇಗೌಡ ಕರ್ಕೊಂಡೋಗಿದ್ದು, ಇವ್ರು ಸಂಜೀವೇಗೌಡ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರು ಹೇಳಿರೋ ಸಂಜೇಗೌಡ ಅಂತ? ಕ್ಲೈಮೇಟ್.
ಈ ತರ ಸ್ವಲ್ಪ ಡಿಸ್ಟರ್ಬೆನ್ಸಸ್ ಇದೆ, ಅದಕ್ಕೆ discuss. ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ಮೋಟರ್ ಸೈಕಲ್ ಸ್ಕೂಟರ್ ಓಡಿಸ್ಲಿಕ್ಕೆ ಲೈಸೆನ್ಸ್ ಇರ್ಲಿಲ್ಲ, ಆಮೇಲೆ ಪಾಲಿಸಿ ಇರ್ಲಿಲ್ಲ, 3 ತಿಂಗಳು ಲ್ಯಾಪ್ಸ್ ಆಗಿತ್ತು ಅಂತ ಇದೆಲ್ಲಾನು ಡಿಸ್ಕಸ್
ಆಲ್ ಕಂಟೆನ್ಷನ್ ಇಸ್ ಲೆಫ್ಟ್ ಆಫ್
ಇದೆಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳ್ತೇವೆ.
ಅದನ್ನೆಲ್ಲ ಡಿಸ್ಕಸ್ ಮಾಡ್ಬಿಟ್ಟು ಅಂತ then involvement of the vehicle is there is no dispute.
ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ವೆಹಿಕಲ್ ಇದು ಇಲ್ಲೇನಾಗಿದೆ, ಈ ತರ ಅವ್ರಿಗೆ ರೈಡರ್ ಆಫ್ ದ ಮೋಟರ್ ಸೈಕಲ್ ಪಿಲಿಯನ್ ರೈಡರ್ಗೂ ಸಹ ಇಂಜುರಿ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರದ್ದು ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಕಲ್ಲ ಅಂತ. ರೈಡರ್ ಆಫ್ ದ ಮೋಟರ್ ಸೈಕಲ್, ಪಲ್ಸರ್ ಮೋಟರ್ ಸೈಕಲ್ ಮತ್ತೆ ಪಿಲಿಯನ್ ರೈಡರ್ ಹೂ ಹ್ಯಾಸ್ ಆಲ್ಸೋ ಸಸ್ಟೈನ್ ಇಂಜುರೀಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ದಿ ರೈಡರ್ ಅಂಡ್ ಪಿಲಿಯನ್ ರೈಡರ್. ಅಫೆಂಡ್ ವೆಹಿಕಲ್ ಮಾಡಿಲ್ಲ. ಜಿನೆನ್ನೆಸ್ ನ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬಹುದಿತ್ತು, ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಅಫೆಂಡಿಂಗ್ ವೆಹಿಕಲ್ ಅವ್ರ ಹೆಂಗ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ?
ಅವರು ಸಸ್ಟೈನ್ ಇಂಜುರೀಸ್ ಆಗಿತ್ತು. ಇಫ್ ದ ವೆಹಿಕಲ್ ಇಸ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ದ ಆಕ್ಸಿಡೆಂಟ್, ದೇ ವುಡ್ ಆಲ್ಸೋ ಸಸ್ಟೈನ್ ಇಂಜುರೀಸ್. They would have produced the.
ನೀವು ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬಹುದಿತ್ತು. ನಿಮ್ಮ
ನಾವೇನು ಮಾಡಿಲ್ಲ.
ಪಿಟಿಷನರ್
just 2 days delay lodging complaint ಅಂತ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ವೆಹಿಕಲ್ ಅಂತ ಮಾಮೂಲಿ ಕ್ಯಾಶುವಲ್ ನಮ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೆ.
Yes, I will left all contents and left open. Yes.
ರಿಮೈಂಡ್ ಮಾಡಬಹುದು.
Yes. Srimati Shardamba A.R. Learned Counsel appearing for claimant has contended that the claimant has suffered an injury in a road traffic accident occurred on 17/9/2016 due to rash and negligent driving of rider of Pulsar bearing registration number KA54J3199. Immediately after that accident, she has been shifted to Yes, she has been shifted to Janapriya Hospital, which place Hassan. As per that exhibit P18 MLC extract, it has been mentioned that RTA. On same day, the hospital authority has sent an intimation to the police mentioning that offending vehicle number is KA54J3199. Since the police has registered an FIR when 19/9/2016, there is a delay of 19 in spite of intimation, the police has not registered an FIR. On 19/9/2016, the brother of the claimant has lodged a complaint. Thereafter, police has registered an FIR. The trial court, only because the complaint has lodged in delay in 2 days in lodging the complaint, has dismissed the claim petition. Ad nimde evidence. How why she has to say that? Yes. Yes. She further contended that pursuant to that complaint, the police has registered an FIR against that rider of the motorcycle and filed on a charge sheet. He has not challenged the same before any court of law. Even the insurance company has not examined any witnesses to disprove the case of the claimant. The tribunal has error in dismissing the claim petition. The finding of the tribunal is contrary to the material available on record. Hence, yes, as per, she further contended that even as per that IME report exhibit P5, both the vehicles has been damaged. Therefore, it is very clear that the offending vehicle was involved in that accident. Hence, he sought for allowing that appeal. Per contra, Sri B. Pradeep, Learned Counsel appearing for insurance company, has contended that the accident was occurred on 7/9/2016. The police complaint has been lodged on 19/9. There is a delay in lodging the complaint. Even as per the evidence of PW1, what is the name?
Manjegoda.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಸಂಜೀವೇಗೌಡ.
When Sanjeevegoda has taken her to that hospital, but as per that hospital record, it has mentioned one Manjegoda. Sanjeevegoda's name is not placed in any records. Therefore, there is a discrepancy in the medical records as well as the evidence of the claimant. Therefore, the tribunal has rightly rejected, dismissed the claim petition. Heard the learned counsel for the parties, peruse judgment and award. It is the case of the claimants that on 17/9/2016 at about 2:30 p.m. the claimant was riding her scooty bearing registration number KA09 EE4496. When they reached near Ashoka Road, which place Hassan, the rider of the motorcycle bearing registration number KA54J3199 came from opposite direction in rash and negligent manner, dashed to that motorcycle, dashed to that vehicle of the claimant. Due to impact, she fell down. Immediately, she has been brought to that Janapriya hospital by one Manjegoda. As per that MLC extract, exhibit P18, it has been reported that the alleged occurrence of injury and the history of accident has been mentioned as RTA. Even as per exhibit, the information, as per exhibit P2, police intimation sent by that hospital authority, that has clearly mentioned that the offending vehicle number KA54J3199 immediately since the police has not registered an FIR as on the basis of the intimation, the brother of the claimant has lodged a complaint on 19/9/2016. Pursuant to that complaint, the police has registered an FIR against the rider of the motorcycle. Pursuant to that, the police has filed a charge sheet against the rider of the offending vehicle. Even as per IME report, exhibit P5, it is very clear that both the vehicle was damaged. The tribunal has failed to consider all these materials which has been produced by the claimant. Only on the ground that delay and the Sanjeev Appa's name has not been appeared in the medical records has dismissed the claim. This finding of the tribunal is perverse, contrary to material available on record. The matter requires to be remitted back to the tribunal for fresh consideration. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. The matter is remitted back to the tribunal for fresh consideration in accordance with law. It is made clear that any observation, the tribunal is directed to decide the matter in accordance with law without influencing any observation made by this court. Yes, time limits beka? Yes. The tribunal is directed to dispose of the claim petition. MEC 404 of 2017 is restored, directed to dispose of as expeditiously as possible. Yes. What is that injury? 2017. 20,000. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್? ಏನು ಇಲ್ಲ. 70,000 ಕೊಟ್ಟಿದ್ದಾರೆ. You have not examined the doctor. Why? What is that injury? ಆಯ್ತು, ಹೆಡ್ ಇಂಜರಿ ಆಗಿದ್ರೆ ಡಾಕ್ಟರ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ, ಅಂತ ಸಿವಿಯರ್ ಇದ್ದಿದೆ. Yes, Mr. Vijay Kumar, what should be the tradition? Yes, Mr. 40,000 rupees will give that with interest, 6% interest. Yes. Heard learned counsel for the claimant has contended that due to that extent, the claimant has suffered grievous injury. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ? He was inpatient for a period of 7 days. He has spent 37,190 for medical expenses, and he has suffered lot of pain during the treatment. The global compensation awarded by the tribunal 70,000 is on lower side. Hence, he sought for enhancement of compensation. Per contra, D. Vijay Kumar, learned counsel appearing for insurance company, has contended that even though ಒಂದೇ ದಿನ one day ಅಂತ ಹಾಕೋದು. Contended that the injuries suffered by the claimants are minor in nature. He has not examined the doctor. Tribunal, considering that injury suffered by the claimant, has granted a just and reasonable compensation. He further contended that even that interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties peruse judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 7/9/2017 due to rash and negligent driving of driver of Maruti Swift Desire car bearing registration number KA 13 B9284. Due to that accident, the claimant has suffered the following injury. He was inpatient for a period of 1 day. He has spent more than 37,190 rupees for medical expenses. Considering that injury suffered by the claimant, I am of the opinion, in addition to that compensation awarded by the tribunal, 40,000 has been awarded with 6% interest. Accordingly, the appeal is allowed in part. Statement and award possible modified.
Vijay Kumar.
Injury na? Yes, sir. Injury. 15. ನೀವು ಎಷ್ಟು ಕೇಳಿದ್ರಿ? ಎಷ್ಟು ತಗೊಳ್ಬೇಕು? ಅಲ್ಲ 2015ಗೆ. What is the age? ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ? 10% ಕೊಟ್ಟಿದ್ದಾರೆ. Yes. Yes, that will consider. Sri Sanat Kumar KM, learned counsel appearing for claimant, has contended that at the time of the accident, the claimant was deceased. It's a case of death. Yes. Contended that at the time of the accident, deceased was earning 15,000 per month. The tribunal has assessed notional income of the deceased as 8,000 per month is on lower side. He further contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, D. Vijay Kumar, learned counsel appearing for insurance company, has contended that even though the claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Therefore, tribunal has rightly considered the notional income of the deceased as 8,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. There was judgment and award. It is not in dispute. Srimati Nagamma died in road traffic. Alala. Who is that? Swami. Yes. Swami died in road traffic accident occurred on 4/10/2015 due to rash and negligent driving of rider of motorcycle bearing registration number KA11 H0695. Even though the claimant has claimed that deceased was earning 15,000 per month by doing a PD rolling work, but they have not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2015, the notional income has to be considered as 9,000. The tribunal has rightly added 10% of the income of the deceased for future prospects and rightly deducted, since there are 4 dependents, 1/4 of the income of the deceased as deducted for personal expenses. The multiplier applicable to that age group, yes, 54 for multiplier applicable to that 11. Accordingly, loss of dependency has been reassessed as follows.
2,000 plus 900, rate of 10%, 9,900 minus 2,475 plus rate of 4, 7,400, 7,400 equal to 11, in that 8,100.
Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, the first claimant is entitled 40, 2 and 3 is entitled 40. 3 already 2 and 3 is Makkalalandre. 3, 4 also. Yes, 2 to 4 are entitled 40,000 each for parental consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as well.
64, curation loss of appellant, he is shown a gola.
Really, very she said, then appear for the appellant, release this matter after 2 weeks.
Number 67, he produced the appellant. Number 67.
That is, their case is also same. ಅಲ್ಲ ಈಗ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆದ್ರೆ ಇವನ್ ಪಿಲಿಯನ್ ರೈಡರ್ ಇಸ್ ಎಂಟೈಟಲ್.
ಏನು ವೆಹಿಕಲ್ ನಂಬರ್ ಸಿಗ್ತಿಲ್ಲ, ಯಾವ ಜೊತೆ ಹೋಗಿದ್ದೆ ಅಂದ್ರೆ ಆ ವೆಹಿಕಲ್ ನಂಬರ್ ಏನು
But why? What is the reason for delay? What is the reason for delay? Tribunal ಏನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಡಿಲೇಗೆ? Yes. Say that they are the institution while you are going into because they of course the road, the person both freedom and the additional sustainability. That the additional was ahead of the right and due to his own part, freedom sustainability. The additional was the main matter on all supports in that as a due to the additional
ಅಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಲ್ಲ. ಮೂರೇ ದಿನಕ್ಕೆ ಪೊಲೀಸ್ನವ್ರು ಬಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತಾರೆ. Then they have to examine the police. ಅಲ್ಲ ಜೊತೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿರ್ಬೋದು. ಹಿಂಗೆ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಗೆ ಒಳರೋಗಿಯಾಗಿ ಫಿರ್ಯಾದಿ ದಾಖಲಾಗುವ ಸಂದರ್ಭದಲ್ಲಿ ಆಸ್ಪತ್ರೆ ಸಿಬ್ಬಂದಿ ನೀಡಿದ ವರ್ತಮಾನದ ಮೇರೆಗೆ ಆಸ್ಪತ್ರೆಯ ಔಟ್ ಪೋಸ್ಟ್ ಪೊಲೀಸರು ಚಳ್ಳೂರು ಪೊಲೀಸರಿಗೆ ತಿಳಿಸಿದ್ದಾರೆ. ಮೇರೆಗೆ ಚಳ್ಳೂರು ಪೊಲೀಸರು 3ನೇ ದಿನ ಆಸ್ಪತ್ರೆಗೆ ಬಂದು ಫಿರ್ಯಾದಿಯಿಂದ ಹೇಳಿಕೆ ಹಾಗೂ ಮಾಹಿತಿ ಪಡೆದುಕೊಂಡು ಹೋದರು. Then they have not examined that this thing. We'll send it back. Let him examine that. ಪೊಲೀಸರು ಎದುರುದಾರ ಮಾಡಿದ ಅಪರಾಧ ವಿರುದ್ಧ ಫಿರ್ಯಾದಿ ಪ್ರಥಮ ವರದಿ ಮೇರೆಗೆ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿ ತನಿಖೆ ನಡೆಸಿದ್ದು. ಫಿರ್ಯಾದಿಯಾರರು 14ರಂದು ಬೆಳ್ಳೂರು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಭೇಟಿ ಮಾಡಿ ಎದುರುದಾರ ವಿರುದ್ಧ ಯಾವ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿದ್ದೀರಿ ಹಾಗೂ ಇನ್ನಿತರ ದಾಖಲೆ ನೀಡಿ ಎಂದು ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಫಿರ್ಯಾದಿ ಕೇಳಲಾಗಿ ಯಾವ ಪ್ರಕರಣ ದಾಖಲಿಸಿಲ್ಲ, ನಿನ್ನ ಮಗನು ಅಪಘಾತ ಮಾಡಿದ್ದಾನೆ, ಆದ್ದರಿಂದ ನಾವು ಯಾವ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸುತ್ತಿಲ್ಲ ಎನ್ನುವ ಉತ್ತರ ಫಿರ್ಯಾದಿ ನೀಡಿರುವುದರಿಂದ ಇಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ ಅವರು ಪೊಲೀಸ್ನವರು ತಗೊಂಡೋಗಿದ್ದಾರೆ. he has not registered an FIR when they have encountered, therefore we have given a complaint, but they have not examined that. Number 91 of 60.
ಕಂಪ್ಲೇಂಟ್ ಯಾವತ್ತು ಲಾಡ್ಜ್ ಮಾಡಿದ್ದು? 27/7/2016. ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ? ಯಾರ ಮೇಲೆ? ಅವ್ರ ಅಪ್ಪರ ಮೇಲೆ. ಓನರ್ ಯಾರು ಇದ್ರಲ್ಲಿ? ನಾಗರಾಜು ಮಗ. ಹ ಅಲ್ಲ, ಭೀಮಣ್ಣ ಇಂಜುರಿ, ಭೀಮಣ್ಣ ಪಿಲಿಯನ್ ರೈಡರ್. ಮಗನೇ ಓಡಿಸ್ತಾ ಇರ್ತಾನೆ, ಅಪ್ಪನ್ ಬಿಟ್ಟು ಮಗ ಈಸ್ 35 years ಮಿಸ್ಟರ್. ಅವ್ರು ಓಡಿಸ್ತಾ ಇದ್ರು ಅಂತ ಕೆನ್ ಯು ಬಿಲೀವ್? ಸಿ ಬಿದ್ದಿರೋದು ನಾಯಿ ಅಡ್ಡ ಬರ್ದಾನೆ ಬಿದ್ದಿರ್ಬೋದು, ಬಟ್ ಥಿಂಗ್ ಈಸ್ ಸಿ 35 ವರ್ಷದ ಮಗನ್ನ ಹಿಂದ್ಗಡೆ ಕೂರ್ಸ್ಕೊಂಡು ಅಪ್ಪ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಯು ವಿಲ್. ಯಾರು ಅವ್ರು ಬಿದ್ದ ಮೇಲೆ ಮಗಂದ ನಿಮ್ ಕೇಸ್ ನಾಗರಾಜ್ ಇರ್ಲೇ ಇಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ ಬ್ರಾಡ್ ಬೈ ಏನಿದೆ? MLC ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್. $17 2015 6 months ಆದ್ಮೇಲೆ ಇಲ್ಲ 17/12 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ, ಇಲ್ಲಿ ಜೂನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನು ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು 27/7. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 27/7 ಇದೆ, FIR ಅಲ್ಲ. Everything is fishy. Therefore, the police has to say ದಿನಾಂಕ 17/12/75 ಥರ್ಸ್ಡೇ 17/12/15 ವೇಳೆಗೆ ಪ್ರಥಮ ವರ್ತಮಾನ 15/8/2016 ಅಂತ ಆಗಿದೆ. ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 27/7/2016 ಅಂತಿದೆ ನೋಡಿ. Let him redo it. Let us see. Policeನವರು ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿ. Let them say whether it is true they have recorded or not. Shri B. Pradeep, learned counsel appearing for the insurance company, has contended that the claimant himself was riding that motorcycle, fell down the motorcycle by skid and fell down. Since there is a self fall, to make a false claim, they have claimed that his son, that is respondent number 1, was riding that motorcycle. He was proceeding as a pillion rider. This is a story created by the claimants to make insurance company as liable to pay that compensation. He further contended that even as per the MLC extract, that claimant was been brought to that hospital. Yaar dasar ide magane Nagaraj anta ide. He further contended that then he might have been not holding properly, he fell down, mister. ಮಗ ಹಿಡ್ಕೊಂಡಿರ್ತಾನೆ, ಬಿದ್ದಿದ್ದಾರೆ. ಮೋಸ್ಟ್ಲಿ ಪೊಲೀಸ್ ಹ್ಯಾಸ್ ನಾಟ್ ರಿಜಿಸ್ಟರ್ಡ್. ಇಲ್ಲ ಅಂದ್ರೆ PCR ಆಗ್ತಾರೆ. ಅದೇ, ಅದರ್ವೈಸ್ ದೇ ವಿಲ್ ನಾಟ್. ಪೊಲೀಸ್ನವರು ನೀವೇ ಅಪ್ಪ ಅಮ್ಮ ಬಿದ್ದಿದ್ದೀರಾ, ಮಕ್ಕಳು ಬಿದ್ದಿದ್ದೀರಾ, ಏನ್ ಕೇಸ್ ಅಂತ ಎದುರಿಸಿದಾರ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಮೇ ಬಿ ಇಟ್ ಈಸ್ ನಾಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಡಾಗ್ ವಿಚ್ ಹಸ್. ಈಗ ಈವನ್ ಸೆಲ್ಫ್ ಫಾಲ್ ಆದ್ರೂ ಕೂಡ, ಸ್ಕಿಡ್ ಆದ್ರೂ ಕೂಡ ಇನ್ಸೂರೆನ್ಸ್ ಪಾಲಿಸಿ ಇಸ್ ಕವರ್ಡ್ ಅಲ್ಲ. ಅಲ್ಲ, ಈಗ ನಿಮ್ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಪಾಲಿಸಿ ಇದ್ದು ಪಿಲಿಯನ್ ರೈಡರ್ ಇಟ್ ಇಸ್ ಕವರ್ಡ್ ಅಲ್ಲ. Then we will dismiss it. Yes. Contended that the complaint has been lodged after 8 months. After the 8 month after that accident, there is a delay in lodging the complaint. Therefore, it is very clear that to make a false claim, they have filed this claim petition. The tribunal has not considered this aspect of the matter. Hence, he sought for dismissal of the appeal. The respondent is served unrepresented. Heard the learned counsel for the appellant. The case of the claimant is that on 17/12/2015 at about 6:30 p.m. the claimant was proceeding on his motorbike bearing registration number KA06 EQ 4973 as a pillion rider along with first respondent, who is none other than the son of the claimant. When they reached near Malachanagutte Gate, Chellur Hobali, Gubbi Taluk, at the time 3 dogs came across the road. Hence, the respondent number 1 was unable to control the vehicle and skid on the road, due to which both of them fell down and sustained injury. Immediately after, with the help of the public, the first respondent has taken the claimants to the hospital. On the same day, as per MLC extract, exhibit P12, it has been written as self fall from the bike when dog came in his way at 6:30 p.m. In the wound certificate, it is also mentioned that claimant, the respondent number 1 has brought the claimant to the hospital. As per the complaint exhibit P1, exhibit P2 complaint, they have specifically stated that immediately after the accident, Chellur police has taken a statement of the claimant. They are under the impression that the police has lodged the complaint and registered an FIR. After 8 months, when they have visited the police station and inquired, the police has not registered an FIR. Therefore, they have lodged the complaint on 27/7/2016. In spite of that, police has not registered an FIR. Then they have filed an idu ಅದರ ಮೇಲ್ಗಡೆ ರೆಫರೆನ್ಸ್ ಆಗಿದಾಗ FIR ಹಾಕಿರೋದು. ಅಲ್ಲಿ ತನಕ ಪೊಲೀಸ್ನರ್ ಮೋಸ್ಟ್ಲಿ they have. Yes. The complaint has been lodged on 27/7/2016. In spite of that, police has not registered an FIR. Therefore, they have filed a private complaint. ಯಾವ್ದು exhibit? Exhibit P9. Exhibit P9 ಏನು ಇದೆಯಲ್ಲ ಪಾಲಿಸಿ ಇದೆಯಲ್ಲ. CC. PCR, yes. Exhibit P9. ಯಾವತ್ತು ಹಾಕಿದ್ದಾರೆ ಇದು? 7/10/2016. He has also filed an PCR as per Exhibit P9. Therefore, in the meantime, the police has registered an FIR as per Exhibit P1. Claimants appeal ಇದೆಯಾ? ಯಾರ್ದು ಹೆಸರೇನಿದೆ? ಅಡ್ವೊಕೇಟ್ ಯಾರು? ಇದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅವರು. ಅಲ್ಲ ಇದನ್ನ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಡಿಸ್ಮಿಸಲ್ ಈಗ ಅವ್ರದ್ದು ಏನಾರು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಇದ್ರೆ ಅದರ್ವೈಸ್ ಅಲ್ಲ ಲೆಟ್ ದೇರ್ ಬಿ ಎನ್ ಫೈಂಡಿಂಗ್ ರಿಗಾರ್ಡಿಂಗ್ ದಟ್ ದಿಸ್ ಥಿಂಗ್ ಅದಿರ್ಲಿ. ನಾಳೆ ಮತ್ತೆ ನಾನು ಇನ್ನೊಂದ್ಸರಿ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಬೇಕಲ್ಲ. ಅಲ್ಲ ಡಿಸ್ಮಿಸ್ ಇದನ್ನ ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಲ್ಲ. ಐ ವಿಲ್ ಕನ್ಕ್ಲೂಡ್ ದಟ್. ಮತ್ತೆ ಇದು ಬ್ರೇಕ್ ಆದ್ರೆ ಮತ್ತೆ ನಾನು ಹ್ಯಾವ್ ಟು ಸಿ ದಟ್ ಎಂಟೈರ್ ರೆಕಾರ್ಡ್ಸ್. ನೌ ಇಟ್ ಈಸ್ ಇನ್ ಮೈ ಮೈಂಡ್. ಐ ಕ್ಯಾನ್ ಜಸ್ಟ್ later in the meantime, the police has registered an FIR on 15/8/2016. Therefore, it is very clear from the above records that there is no delay in lodging the complaint, since the police has not registered an FIR. They have to give a fresh complaint in 2017. And as per IMA report idea. As per IMA report Exhibit P5, the offending vehicle is also damaged. Yes, after the release this matter along with that MFA
3245/22
on Monday. Yes. Allah, usually no, there may not be any point in you because nobody is represented. I also thought that ಅಲ್ಲ ಅವರು ನಿಮ್ ನೋಟಿಸ್ ಹೋದ್ಮೇಲೆ ಅವರು ಲಾಯರ್ನ ಅವರಿಗೂ ಹೇಳಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ದೇರ್ ಮೇ ಬಿ ಸಮ್ ಕನ್ಫ್ಯೂಷನ್ ಬಟ್ ಇಟ್ ಈಸ್ ಸರ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್. ಓ ನೋಟಿಸ್ ಓದಂಗಿಲ್ಲ ಅದನ್ನ. ಆಯ್ತು ಬರ್ಲಿ ಅದನ್ನ. ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ ಗ್ರೌಂಡ್ ಫಾರ್ ದಿಸ್ ಥಿಂಗ್ ವೈಲ್ anyhow that let him argue. Don't this thing we have court has taken any this thing. It's still left open. Let us see what is his argument. Therefore, I have not passed any final conclusion. Okay.
ಅದೇ ಬಂತಲ್ಲ ಹಳೇದು ಬರ್ತಾ ಇದೆ. ಅಂದ್ರೆ ಇನ್ನು ನಮ್ ಕಡೆಯಿಂದ ಆಗಿಲ್ಲ ಅಂತ ನೀವು ಪ್ರೊಸೀಜರ್ ಏನ್ ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು. ಇವತ್ತು ಅಪ್ಲೈ ಮಾಡಿದ್ದೀವಿ, ಇವತ್ತು ಅದೇ ಬಂತು, ಏನ್ ಮಾಡ್ಬೇಕು? ಇನ್ನು 4 ದಿನ ಬಿಟ್ಟು ಅಪ್ಲೈ ಮಾಡಿ. ಹೆಚ್ಚಿಗೆ ಆಗಿತ್ತು ಅವ್ರಿಗೆ ಇಲ್ಲ ಮೇಡಮ್ ಹತ್ರ ಇರ್ತದೆ. ಡಿಕ್ಟೇಷನ್ ಕೂಡ ಆಗೋಗಿದೆ, ಜಡ್ಜ್ಮೆಂಟಲ್ ಆಗೋಗಿದೆ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಫೈಲ್ ಇದೆ, ಪುಟ್ ಅಪ್ ಮಾಡಿ ಸೋಮವಾರನೇ ಬರ್ತದೆ. ಇಲ್ಲ ಇಲ್ಲ ಒಂದೇ ಒಂದು
ಫೋಟೋ ಕೊಡ್ಬೇಕಾ, ಪೆಂಡಿಂಗ್ ಪೆಂಡಿಂಗ್ ಕೊಡ್ಬೇಕಾ? ಪುಟಪ್ ಮಾಡಿ ಹೇಳ್ಬೇಕಲ್ಲ.
ಏನೂ ಆಗಿಲ್ವಂತೆ ಎಲ್ಲ ಅಂತ ಇದ್ರು. ಗೊತ್ತಾ ಟೋಟಲ್ಲಿ ಟೋಟಲ್ 100 ಅಲ್ಲೇ ಅವರೇ, 3 ದಿನ ಟೋಟಲ್ 200 3 ದಿನ ಅಲ್ಲೇ ಅವರೇ. 6 ಜನ ಎಲ್ಲ ಸೀರಿಯಸ್ ಆಮೇಲೆ ಯಾವ್ದು